Ay po. Hmm.
Hello, Mr. Vanani, Mr. Romano, Tandeka. Hi.
Good
Good
morning,
morning,
David.
Mr. Lewis. How are you?
Oh, good, and you? Good.
I'm
Thank you.
good.
Good.
Is it you who will be sharing the presentation?
Yes. Should we put it up now?
Yeah, maybe we can try and see if everything is fine.
Okay, good. It is. So share there,
Mm-hmm.
and where do I find it? PowerPoint.
Well, you have a lot of PowerPoints that are open. Do you want to just
Yeah.
close these PowerPoints? This is the only one that's open. Do you know?
Yeah, I think that's the only one that's open.
Okay, let's try.
This the one, the right one.
Hmm. Um, you have a system issue, so it's not allowing me to share. Oh, wait, there we go.
What password must I use?
I'm not sure what the
As the
password is.
password of my machine.
Yeah. Hmm. Okay, Vunani, we're just going to rejoin in a second.
Okay.
Can you give us access? Never mind. Got it. There we go.
Maybe this is on your computer. Have we got it?
Wait, yeah, just since this one needs to be shared. Can you confirm that you can see the slides?
Yes, I can see it.
Okay, great.
Thank you.
Okay. And how do I turn it down? I just flip it down.
You're just gonna use your,
Okay.
Yeah.
Okay, great. That one.
yeah, I'm gonna put you on mute whilst we're waiting.
Can you put it down for now and then share again when the chairperson invites you to do so?
Good morning, members. Good morning to all the attendees to the meeting today. Today we'll be dealing with two items.
Recording in progress.
The first item will be a submission by the National Anti-Corruption Advisory Council in respect of the 21st Constitutional Amendment Bill. We later will take the Magistrate Commission on the suspension of magistrates. I see that the chairperson of NACEC is already on screen. Good morning, Mr. Katalia.
Thank you, Chair. Good morning to you as well. Professor Kachalia is overseas on a long-standing commitment that he'd made. So I'm one of the members of NACAC, David Lewis, and I'm going to do the presentation on his behalf. The deputy chair also apologizes because she has a traditional leaders function that she has to attend, but several other members of the commission are online as well, and they'll help me with answering the questions that'll inevitably arise.
Okay, thank you for that, Mr. Klaus. Can you introduce the delegation you came with?
Yes, I'm not absolutely sure who's here, but I see Tandeka Kubule Mbeki is here. She has been working on principally on whistleblowing issues. Kavisha Pillay is here. She's been examining a variety of anti-corruption legislations. I'm not sure if Advocate Kumalo is here, who's been working on procurement. Councillor Barbara Schreiner, who is South African, based in Berlin, is here. She's been working on institutional architecture and procurement. I'm here, and I've been working on I've been coordinating the institutional architecture and the strengthening the law enforcement agencies' work, which is mainly the subject of the bill, which is why, I've been given the task of doing this presentation today, because that has been my task on the committee. I don't think Councillor Delope is available today. I think that's about it. I'm not sure if Councillor Schreiner and Delope are on, but certainly Councillor Pillay and Councillor Kubule Mbeki is on, and whoever else is here. I can't really see. Let me look at the participants. Maybe it'll help me.
Okay, let's do like this, Mr. Klaus. I see Councillor Kubule Mbeki is on the screen.
Yeah.
Who else? Can you show your faces on the screen, councillors?
Sure. Commissioner Pillay is with me, and she is here, helping me in the case I can't work any of the tech. And are there any others? Councillor Kumalo, if you're here, show yourself on the screen. Councillor Schreiner. I'm not sure which of them are here or in yet. There are several people in the waiting room, I see.
Okay, maybe they will show when we are interacting with the submission. Members will start with NACEC, but I think it's important to indicate that we've received a letter from the Minister of Justice apologizing for not being available today. They have a cabinet meeting. We have an apology from Mr. Sotetsi, who's also busy with examinations. Committee Secretary, do you have any further apologies? Mr. Swart, your hand is up.
Chairperson, good morning to you and colleagues. Again, I need to apologize to attend the Chief Whip's forum in a little while, so I'll be leaving early. Thank you. I also noticed that there were some members struggling to get onto the platform. I hope they've got on by now. Thanks, Chair.
Okay, thanks, Mr. Swart. Committee Secretary, do you have any further apologies on your end?
Good morning. Nothing from my side, Chair.
Are there members who are still on the lobby?
I don't see anyone. Yeah, I see there are people who are waiting, but I'm struggling to see who those people are.
But it's not members.
Okay, no, they are members. Yeah, I've just admitted them.
So you have admitted all the members who were in the lobby.
Yes.
Thank you very much. Now we can proceed. Mr. Lewis, you can proceed with the submission on behalf of NACEC.
Right, we'll share a screen. Okay, can I confirm that you can see our screen?
Yes, we can see them.
Good. Well, thank you, Chairman, and thank you to all the members of the committee for the invitation to address the committee today in what is an important issue, to put it mildly. And what we have done is that we've prepared what I hope is going to be a brief presentation, and rather than focusing on retelling the story of the bill or the content of the bill, which I'm sure you know very well, we've presented our proposals and in one slide attempted to contrast the bill with our proposals. Because although we share the private members' concern with corruption, and there are issues on which we agree, on fundamental issues we disagree. And so, in some sense, we're grateful for this bill having been presented because it's focused the minds on the issue. But we do think that there are significant flaws in the bill, and that's what we'll try and present to you. So to first give you the story of NACAC briefly, we were appointed in September 22 for a 3-year term that ends in August, at the end of August this year. We consist of 9 members, and the council is chaired by Professor Feroz Kachalia, who, as I explained to the chair, is unfortunately out of the country and not available today, or else he would be in my seat. And the council was established to advise the president, firstly, on an all-of-government, all-of-society approach to combating corruption. So, just in that alone, the president has demonstrated that fighting corruption is not the task of a single agency or a single government department or a single prosecutorial agency. It's the task of all of government and all of society. Secondly, he's asked us to advise on South Africa's anti-corruption institutional architecture, which is what we will speak about principally today, because that's principally what the bill before you deals with. Thirdly, he's asked us to advise on implementing the national anti-corruption strategy. This was a strategy finalized a long time ago, well, several years ago, and has been adopted by cabinet, and I presume that many of you are familiar with that. And then he's asked us to monitor the implementation of the strategic recommendations of the State Capture Commission of Inquiry. So it's not the recommendations that they have made concerning the prosecution of this or that individual. It's where they have made recommendations essentially about the institutions of the anti-corruption architecture that we will that our attention is drawn to in the report of the Zondo Commission. So those are what our tasks are. It's not changing here. maybe. Sorry, I just okay. In the first phase, what we did were that we established work streams which covered the following areas. First, institutional architecture and strengthening the law enforcement agencies. That's been the task of one of the work streams. Secondly, reviewing anti-corruption legislation. Thirdly, on public procurement. Fourthly, on whistleblowing. Fifthly, on communications and behavior change. And sixth on monitoring and evaluation. Those were the work streams established in the first phase. And by the end of that phase, in June 2024, NACAC had already consulted with a wide array of stakeholders in each of these fields. We had convened 2 widely attended national dialogues on corruption, which some members of the committee may well have attended. They were attended by government, by business, by civil society, by labor. And they were both, as I say, held in December on Anti-Corruption Day, and went over 2 days, and both were very successful, in which we canvassed our work and our ideas. We've submitted various advisory opinions to the president, and in particular, we've submitted a midterm report to the president, which is what we will deal with here. So these are the midterm report recommendations, principally of the work stream dealing with institutional architecture. Now, we have recommended to the president that a new anti-corruption agency focused on the prevention of corruption be established. We have called this the Office of Public Integrity. Obviously, there's the name is up for contestation, if you like. But the essential thing is that this is an anti-corruption agency focused on preventing corruption. And the OPI, the Office of Public Integrity, this new agency, is intended to be, at least in our recommendations, a statutory Chapter 9 body, which will incorporate the Special Investigating Unit, the SIU. Now, I'll say much more about that as we go along, but this is the essential architecture change. The largest architecture change that we have recommended is the establishment of the OPI, a new agency focused on prevention, which, if our recommendations persuade the decision makers, will be a statutory Chapter 9 body incorporating the SIU. And the reason why we have established an agency concerned with prevention is, and I'll repeat this throughout this presentation, is that while law enforcement is fundamentally important, and as you'll see, we have given a lot of attention to strengthening the law enforcement agencies, it's an insufficient deterrent to corruption. And this is not only a South African experience. This is not only as a result of the weakness of the law enforcement agencies. All over the world, the ability to successfully investigate and prosecute corruption is low. And when you weigh up the risks of engaging, or when a person wanting to engage in corruption weighs up the risk of engaging in corruption compared to the material gains from engaging in corruption, corruption is an insufficient deterrent, because the gain side is much larger than the risk side. And that's why we have got to, and this is the experience of the world over, focus our activities to a greater extent on corruption, on prevention. And what the OPI will do as part of its as its preventive task is firstly conduct public education, public mobilization, and behavior change activities. This is very important and quite a contested area, but we are talking about a behavior change program of the scale that we adopted during the AIDS crisis, which was successful in changing the behavior of many people. And similarly with corruption, we have to be talking about integrity, ethics, and the behavior of individuals and communities, and persuading them to understand corruption, to understand its effects, and to change their activities. Secondly, the body will produce policy research and advise government on policies it considers to be effective, or for that matter, ineffective in combating corruption. Thirdly, and very importantly, the new agency will gather data and it will provide analytical and corruption intelligence reports. This, again, a very important area. It's sometimes very difficult to measure the success and the failure of anti-corruption programs, and this agency will gather the data to provide a data-based answer to those questions about effectiveness. Fourthly, and I want you to pay particular attention to this, it will conduct investigations into systemic corruption with binding remedies. Now, these are, I really want to underline this, these are not criminal investigations. These are investigations into situations where you come across a public agency or a government department or a state-owned enterprise in which corruption is so pervasive and so frequently reported on that there is reason to believe that there is something wrong with the governance and the management systems in the organization, and that what the investigation of systemic corruption does is it investigates the decision-making structures in the organization, the manner in which it practices procurement, how its leadership was appointed, to see if there's not a systemic reason for why this institution appears to be so corrupt. And the SRU does this already, and in its reports, it suggests remedies for correcting the system failures, but they seldom come to light. The public and the decision makers seem mostly concerned with the recommendations where they come across criminal conduct and they report criminal conduct to the NPA. They seem more concerned with those remedies than they do with the systemic remedies. And we want the systemic remedies to be binding. And I'll come back to this as we go along. Secondly, fifthly, the role of the OPI will be to coordinate an all of government, all of society approach, similar to the national dialogues, which we have had now for 2 years running, but we will make this a permanent activity, or not only a once-off conference activity, but we will bring in all those government institutions, local government, provincial government, government departments, the Public Service Commission. These are all institutions that are vital in preventing corruption. And that's the task of the OPI will be to coordinate these efforts. We will conduct corruption risk assessments and prevention, relying on the data which we've gathered. We will see where there is corruption, where the largest corruption risks are. And it's such a pervasive problem that to take a risk-based approach to how to deal with it is very important. And finally, it will concentrate on civil asset recovery, which again is something that the SRU practiced pretty successfully to date. So if you compare the NACAC recommendations with the private members bill, you will see similarities. We both recommend a new agency. Both recommend that the new agency should have Chapter 9 status. But then the differences arise. Our new agency focuses on prevention, or our recommendations focus on prevention They focus on strengthening the law enforcement agencies, and they adopt or maintain the multi-agency approach to fighting corruption that the government has always identified with. In other words, we do not think that one single agency is capable of fighting corruption. We think that the whole of government and the whole of society has to be involved in this effort, and that there shouldn't be a single agency responsible for fighting corruption. On the other hand, the private members bill, while on the same page as us in recommending a new agency and recommending that it be a Chapter 9 body, the new agency in the private members bill will concentrate on criminal investigation and prosecution only, and it's a single agency approach. There's nothing said in the bill about how this will engage, and it is the engagement of law enforcement agencies with other public agencies or private agencies is a difficult coordination to manage. And so they have a single agency approach. And those are the critical differences. I'll repeat, both of us want a new agency, but ours is focused on prevention. The bill is focused on criminal investigation and prosecution. We want to strengthen the law enforcement agencies. They want to add a new law enforcement agency to our arsenal, and we favor a multi-agency approach.
Hold on, Mr. Lewis.
Okay.
Committee Secretary, what's happening in this meeting? Are we hacked? There's a person who just burst in a loud disturbance here. Okay, I can't see what is.
Should I continue?
Yeah, you can continue, Mr. Lewis.
Then on prosecution, our recommendation is that the investigation, this is slightly misleading, this entry onto the slide, and I apologize for that. Our recommendations on prosecution is that the investigation and prosecution of serious corruption is to remain with the DPCI, the Directorate of Priority Crimes Investigation, or the Hawks as we know them, and with the Independent Directorate Against Corruption, which is a directorate within the National Prosecuting Authority. We think those two agencies, the DPCI and IDAC, should be responsible for investigating and prosecuting serious corruption. The private members bill recommends that serious corruption be investigated and prosecuted by this new prosecutorial agency. In other words, that task should be removed from the Hawks and it should be removed from IDAC, and both investigation and serious corruption should be in the new prosecutorial agency. And then finally, ours is an all of government and all of society approach. Theirs is an approach on criminal justice only. And I just want to underline something here. We are not in favor of a body that has policing powers to be given Chapter 9 status, because we believe that a body that has policing powers, as the new agency recommended by the private members bill proposes, the powers of arrest, the armed power, should not be totally freed of executive accountability. It's a dangerous recommendation for the security of society to have a policing body that is absolutely out of the hands of the executive. The prosecutorial body must be protected from executive interference. But this is not the case with the policing body, and we believe, quite a dangerous and reckless proposal to make. Now, these are our midterm report recommendations to strengthen the law enforcement agencies. I've spoken about our recommendations around the institutional architecture. These are around the law enforcement agencies, how to strengthen them. And we recognize, as does the private members bill, that there is much lacking in our investigative capacity and in our prosecutorial capacity. And these are the recommendations we make to strengthen the law enforcement agencies, or that we made in the midterm report recommendations. And some of this, as you will see, is work in progress, but others is completed. So as far as the National Prosecuting Authority is concerned, what we want to propose is that they be given administrative autonomy. At the moment, we face the anomalous situation where the accounting officer of the NPA is in the Department of Justice. It is not in the NPA itself. And what this leads to is a very difficult situation with respect to staffing decisions, salary decisions in an agency which competes for scarce skills with the private sector. So we have strongly recommended, and we do feel very strongly about this, that this should be an administratively autonomous organization with its own accounting officer, accounting to Parliament. And that's quite a widespread view by most. I'm certain that the private members bill, those who have proposed it, will agree with that. Secondly, we want to strengthen the security of tenure of the head of the NPA and possibly of the deputies and provincial heads immediately reporting to her. We want the appointment procedures to be re-examined and amended. At the moment, the appointment of the head of the NPA lies entirely within the prerogative of the president. We don't believe that's a good procedure. And many of you will know, when the current head was appointed, the president himself appointed a selection committee to manage the process and to advise him and assist him in the process. He still makes the final decision, but there is a process of selection which I think many of us have had to go through for our jobs. And so to make this a transparent process in which an expert selection committee is appointed, which would undoubtedly include somebody like the chair of this committee, and these would make the recommendations to the president on the appointment of the head of the NPA. And then we've also been dealing with the mandate of the Independent Directorate Against Corruption. I'll say more about this in a minute, but this is still a work in progress. It's a difficult, sensitive area, but we are working on this. And we are also working on examining the resourcing of the NPA. Now, as I'm sure you're familiar, if you ask any government agency what it is that they want, they'll tell you more resources. And so we're looking at the resourcing and the staffing of these agencies, and that continues into the second phase of our work. As for the Hawks, we are examining their mandate, as I've said to you earlier, just as you can't examine the mandate of one without examining the mandate of the other. So we're looking at that, and I'll give you some of our preliminary thinking on that. And we are looking at the resourcing of the Hawks, which is a significantly under-resourced body. With regard to the Special Investigating Unit, we are proposing the merger with the OPI. And I just want to say something more about the merger between the SIU and the OPI. The SRU carries out already many of the prevention functions that we are proposing the OPI undertakes, and we don't want to duplicate these roles unnecessarily. But also the SRU has resources, it has offices, it has a presence in all 9 provinces. It has management systems, it has financial systems. We don't want to have to, if possible, replicate those. And that's why we think that from the point of view of duplication, but also from the point of view of economy, in time and in money, a merger between the SRU and the OPI would be the way to go. And we've had considerable engagement with the SRU talking about this. And then on the coordination of the law enforcement agencies. Now, the law enforcement agencies, or the agencies that have a role in law enforcement that will be left, are SAPS, the South African Police Services, the Hawks, the NPA, IDAC, which is their division responsible for investigating and prosecuting serious corruption, and then the SRU and the OPI. And I just want to stress, the SRU and the OPI don't do criminal investigations. But what happens is that when they investigate rotten systems like Tembisa Hospital or PRASA, whatever the case may be, they often, in the investigation of systems, come across evidence of criminal conduct on the part of individuals or syndicates of individuals, and they need to hand that over to the prosecuting authorities. And then finally, we want this coordination mechanism to have a statutory basis. There is a provision of the SAPS Act, which would provide, if you like, the statutory basis, but it would be in the new legislation as well. But legislation is going to have to be, at the moment, there is no legislation governing the coordination of the law enforcement agencies, and it would have to come either by way of an amendment of the Act, of the SAPS Act, or in new legislation. Now, to just speak briefly about our phase 2 work, which commenced after the June period, June 24 period, we are working on the institutional development of the OPI. So we are intent on presenting to the government a holistic report that will not only make the recommendation, but will make recommendations about how the recommendation could be implemented if affected. And one of our 2 work streams in the second phase is looking at this institutional development. And what it's done, and there's a fair amount of overlap between the 2 work streams, as you'll see. They are looking at understanding and defining systemic corruption in a way that is not only bulletproof in legislation, but that will be understood by the public. And the simplest definition that I could think of, although maybe it will be too simple for the lawyers, is that where corruption is so pervasive as to suggest problems with the system, then the OPI will be entitled to carry out an investigation of systemic corruption. But this work stream is looking, as is the other work stream, looking at how to define systemic corruption. Secondly, they're specifying the mandate and the attendant powers within the prevailing institutional architecture. So it's maintaining the multi-agency approach, but it's refining them. I mean, for example, the SIU has, and the OPI in our recommendation will have, the power to compel people to provide evidence under oath. They have the power to search and seize documentation, and I think property if necessary. And these will all be necessary in order to do the investigations of systemic corruption. Thirdly, they're looking at the governance and roadmap towards attaining Chapter 9 status, which is our preference, or a statutory body. We'll be advised by you on this. But if this legislation and the establishment of the new institution is going to take 4 or 5 years, there is no doubt that corruption will have developed since then in a manner in which we're going to have to consider this whole thing afresh. So we are looking at how to get to a Chapter 9 institution. Does that delay setting up the new institution? What are the transitional mechanisms? Can the SIU be strengthened in such a way as to enable it to carry out already a large number of the functions that we're recommending should be undertaken by this body, so as to short circuit the way of establishing the institution? Fourthly, we're looking at the funding model for the body. At the moment, the SIU has a funding model which enables it to charge government agencies for investigations that it undertakes. The government agencies owe the SIU a fortune. It doesn't seem like the way to go. And so we're examining alternative funding models for this organization. And then at the end of May, we'll undertake a stakeholder consultation workshop to which I don't doubt your committee will be invited, to test these proposals before refining them and integrating them into the final NACAC report. And then finally, work stream 2, which is looking at strengthening the law enforcement agencies, which is the which is the work stream that I am involved in the coordination of. We still have consultations before the end of our term to undertake with various important stakeholders, yourselves, as we're talking to today, but SAPS and particularly crime intelligence. We are, I have to say, not hearing good things about the capacity of crime intelligence, and it's a vital instrument in the combating of corruption. So we want to engage. We were supposed to have a meeting with SAPS a couple of months ago, but it got postponed at the last minute. So we still need to engage with the commissioner and his management team, but with particular attention to the state of crime intelligence. We need to speak to the Minister of Police. We need to speak further with the Minister of Justice, with whom we've already engaged and enjoyed a fruitful engagement with her, but we need to engage with her further. And then secondly, we're researching firstly the corruption mandates of IDAC, Hawks, and the SAPS. And I just want to tell you here that there are 2 possible models. All of these agencies, especially IDAC and the DPCI, are responsible for investigating serious corruption. SAPS is not responsible for investigating serious corruption, but for investigating that kind of corruption which can be investigated at a police station level by detectives. And those detectives have to be trained in investigating corruption. IDAC and the DPCI are both mandated to investigate serious corruption. And we face the alternative either of taking the mandate for investigating serious corruption away from one of them, in which case IDAC would cease to exist for the most part, or we face another interesting possibility which has been presented to us by the stakeholders, is make IDAC the agency responsible for investigating the most complex corruption crimes. those crimes that require sophisticated forensic investigation, that need IT experts to untangle the corruption, where there are cross-border flows of money that are involved. And so we want the IDAC to be a lean, mean, expert organization, not a large agency that competes with the hawks for detectives and forensic experts and those sorts of skills. We want it to be the agency that investigates the most complex crimes that will be assigned to it by the coordinating agency that we recommended earlier. So when the coordinating agency comes across maybe a Steinhoff scale act of corruption, or some of the major corruption in some of the state-owned enterprises, it may very well decide that this belongs with IDAC. The hawks will continue to investigate serious corruption, but the hawks' mandate at the moment is absolutely unachievable. They are responsible for investigating serious contact crimes, gender-based violence, organized crime, serious corruption, serious commercial crime, and their agenda and their roster is too full for any agency to carry out, especially when they've got to investigate serious complex corruption as well. And then, finally, we're looking at the resourcing of the anti-corruption mandates because, as I've said, we want the IDAC to be a lean, mean organization, but it has to be able to compete with the private sector for experienced lawyers, for forensic experts, for IT experts, and the like. And so that will affect its resourcing, even though we insist that it be an organization that is limited in size. And then we have to look at the hawks as well and look at both their undoable mandate, unachievable mandate, as well as the resources that they will need just to look, for example, at organized crime, serious corruption, and serious commercial crime. And that, Chair, is the end of our presentation, and we're available to take questions. But thank you for your attention.
Thank you very much, Mr. Lewis. On behalf of NACEC members, can we therefore interact with the presentation by NACEC? After we have interacted, we'll therefore take Advocate Bredenbach as the sponsor of the private members bill, if she has anything to raise in respect of what would have arisen in the meeting. We'll take Honorable yeah. Wait a little bit, members. I'm still oh yeah. We'll take Honorable Nomvalo, Honorable Matafa, and Honorable Klopa in that order. Honorable Nomvalo.
Yeah, thank you very much. No, I'll be as short as the presentation was.
I know you when you start with that line.
Now it's in a literal sense, Chair. No, I think I have more questions than contributions. The first question is with regards to the proposal that, or the recommendation that they are making for the establishment of the Office of Public Integrity, which they recommend to have a Chapter 9 status. Now, the question that I have is, are we not making a duplication here of a bureaucracy of institutions? Because already we have the public protector's office, which also is a responsibility in terms of the Constitution to investigate corruption in public institutions. And have you done an assessment of the shortfalls or the constitutional inefficiencies now with regards to the office of the public protector, which necessitate the recommendation that you are making? Where is it that, where are the gaps in the Constitution with regards to the powers of the public protector in fighting corruption? Because I have a problem with trying to solve every problem with recommending an institution when we already have institutions which have a constitutional duty to fight corruption. And in my view, we have enough institution. The problem is the institutional capacity, and two, the problem is the lack of competency in the personnel now that are running those institutions. Then the second one is with regards to the mandate for which you were established in 2002. One of the mandates that you were given is to help the president to expedite the implementation of the recommendations of the Zondo Commission. Now, my question is, if you are to rate yourself, well, I wouldn't be hard on you because you've just been established. 2022 is just a few years ago. Now, but if you are to rate yourself now or your performance in this regard, how would you rate yourself in terms of advising? I know that it involves many institutions, the implementation of the Zondo Commission recommendation. The NPA is involved as well, the police and so on and so forth. But the question is, how can you rate yourself? Have you been able to recommend or to advise in an effective manner to the president on how he can speedily influence the institutions which have a responsibility to implement the Zondo Commission, the Zondo report recommendations? So how can you rate yourself? Because we have a concern here, some of us as members of this committee, that the report or the pace to implement the recommendation is very slow, and the reasons that have been given are not fulfilling. Yeah, those are the only, or the last one is with regards to the whistleblower, because you have mentioned that the whistleblowing also you advise on it. Now we have a concern here about the lack of protection on whistleblowing or on whistleblowers, whereas they have a very vast and impactful impact in fighting against corruption. But we always hear every month that a certain whistleblower has been killed here and there. So have you made an assessment in that regard? And if so, have you made any recommendation to dilute that prevalent atrocity? Thank you very much.
Thank you.
Thank you, Honorable Matafa. No, let's, Mr. Lewis, let's take them, just note the questions, then we'll come and deal with them at once.
Yeah.
Honorable Matafa.
Thank you very much, Chair. Good morning to you, members and guests on the platform. Chair, let me appreciate the presentation from Ntate Lewis, and maybe start with just a few questions around their planning process or studies that they would have conducted to eventually arrive at the formulation of the Office of the Public Integrity. The first one, Chair, is on measures to be employed to avoid overlaps and duplications. Honorable Nombalo did touch on the issue of duplications. The risk, Chair, associated with duplications is that it might lead to interagency conflicts if this particular overlaps are not managed in a manner that will ensure that all institutions who carry similar mandates work in harmony. And that can also lead to what one can call institutional redundancy, where one institution might believe that, no, this new body will deal with this particular issue, and then sit back only to find that the other one is also not at that level. So that would be my first question. The second one is on the feasibility study as it relates to the cost. For me, I believe it is always easier to strengthen what you have. So for me, the first prize would have been to strengthen the institutions that are currently in existence rather than start a new one. Appreciating the challenges that we have currently as far as the rampage of corruption is concerned, it makes sense to establish a new entity. However, has there been a feasibility study conducted to say in its full completeness, this body will cost an X amount, and how will this be funded? Are there recommendations from NECAC to be able to say, this is how this institution should be funded? From what ministry, or will it be a direct charge to the National Revenue Fund? Chair, having said that, it makes sense that we establish a new anti-corruption body. I will also link this to the judgment issued in the Glenister 2 case, where the court emphasized the necessity for an anti-corruption body that is both operationally and structurally independent. The point of emphasis is this part, yet integrated within the existing constitutional framework. Now, I see NACAC is proposing that the OPI is integrate or will incorporate the Special Investigating Unit. The presentation does touch on other investigative bodies in the state. My question is, will incorporating the SIU alone fulfill the spirit of the Glenister judgment to say whatever body that we establish, it must operate within the current existing constitutional framework? And those will be my questions, Chair. Maybe one last input. In thanking Advocate Breitenbach for the work that she has done, I think it is also important that as and that Louis is saying, he believes that there are weaknesses in the proposed bill by Advocate Breitenbach. I also believe that there could be areas that maybe can be considered for incorporation that bring some unique aspects in terms of investigations and combating corruption is concerned. Because looking at the bill of the private members bill by Advocate Breitenbach, even though, according to me respectfully, I think it falls short to fulfill the spirit of the Glenister 2 judgment. However, it has its own strength, and I think that it will only be prudent for NACAC and the committee as well as Parliament to consider some of those strong areas as presented in those bills, and be thankful that we have members who will go through such lens to ensure that they assist the country fight one of the biggest challenges that we are facing, and the issue of corruption being one of those that we are fighting. Thank you very much, Chair, for the opportunity. I appreciate it.
Thank you, Honorable Kloba.
Thank you very much, Chair. Good day, honorable members, and Mr. Lewis. Thank you for the presentation. I don't have much to ask, just here and there. I think it was recommendation 2. It was speaking of incorporating or absorbing the existing special investigation unit. I just want to understand, does it absorb it in totality, that it falls under one and that SIU would not exist on its own? That's just the one question. I would also like to know what engagements has there been, particularly public civil, but MPA and SIU particularly. I know there was mention that, you didn't speak to the police yet, and that hasn't happened. I don't know, this term is almost ending, if I read correctly. I think it's in August. Will this be achieved? And I just want to know what their opinion is on this concept. Then I just have one more question, rather broadly. Sorry, I just getting into my notes. I think it's very critically important that we have an effective prosecution in the fight against corruption. And I just want to understand, sorry, man, my skin keeps jumping. We had that discussion on the not centralizing the antibody corruption into one singular. But how does this assist to lower corruption if the NPA isn't actually doing any successful convictions? And we know about this. We know about the Zondo report. People haven't been prosecuted and still enjoying a life within state institutions. Yes, it's implications and so forth, but there's no successful prosecutions. I can believe we can have as many institutions as we want. If we don't get a successful prosecuting authority, then it becomes a lost clause. And I just want to know, how do we reconciliate recommendation 15 and strengthening the NPA's role in anti-corruption if they're not fulfilling their duty? And I say this because it's not just about being under-resourced. We know, we're sitting with it currently, that there's judgments blatantly calling out the NPA on poor performance and willful misconduct, poor prosecution, and that becomes a whole different ballgame. So we're sitting, I think it's on Friday, Chair, to listen for poor prosecution that took place. So I just want to understand, if we keep the prosecution the same and we change the investigation, how do we be better off fighting corruption? Thank you, Chair.
Thank you, Honorable Mhlala.
No, thanks so much, Chairperson. Let me take an opportunity and greet the members of the Portfolio Committee, extend also the greetings to the members of NACEC that are here with us today in the meeting. Chairperson, I don't have a lot of questions, but the first thing I'm interested with is, are we not going to have another state entity that will end up being like a white elephant, where we will not get what we want? Because previous institutions have showed us that they are not capable to deal with issues of corruption. Corruption is rampant today in South Africa. We had these institutions that the presenter presented about. Now we are introducing another agency, which I don't think that will assist us going forward, because it happens with all other departments or all other departments in government. When the entities fail, they start another entity, which of each we don't have proof that the entity will work for us. But I've got a question, Chairperson. I saw that on the presentation that they mentioned that there will be an integration of the SIU into the proposed Office of the Public Integrity. So the SIU at the moment answers to the president, raising concern about executive interference. The speaker spoke about that, And he also mentioned that's why they need autonomy in administration of a lot of things that he mentioned here, because he also feels like the president is the one that is appointing the committee that deals with the appointment. So where is the independence there? But now this SIU that we are going to integrate the OP with, it also answers to the president. It also raised concern of the executive interference. A truly Chapter 9 institution, independent Chapter 9 institution must report directly to Parliament, not to executive. So how is that going to happen? Can you please just take it thorough with that one so that we understand exactly what is going to happen? Chairperson, the other input that I want to bring is the fragmentation of mandates across the NPA, SAPS, and the Hawks, and SIU has been a long-standing enabler of elite impunity. A multi-agency model cannot succeed without clear lines of accountability, whistleblower protection, and independent prosecution mechanism. The report lacks mention of corruption within the SAPS and the Hawks themselves, particularly regarding the complicity in economic crimes and political interference. Why does the NECA presentation ignore systematic corruption within SAPS and the political shielding of top brass by the ministers? So my question is, what is the NACAC stance on the appointment of politically aligned individual leadership in these entities, and what are they going to do in terms of that, Chairperson? Chair, the last question I think that I want to raise here is also about the whistleblowing and public protection. Chair, the whistleblowers like Babita Decoram has been assassinated for exposing corruption. The existing legal and security framework is grossly inadequate. No concrete proposal is presented in the midterm report to fund or institutionalize whistleblower protection beyond reviewing legislation. Will NACAC recommend a dedicated whistleblower protection fund? And if not, why does the presentation not propose the creation of a whistleblower protection agency separate from the police to ensure the neutrality? Chairperson, I saw in the presentation, a lot of things are still in progress, when corruption is very rampant. So what is the agency of these things? The presenter must tell us when are they going to finalize a lot of things that he mentioned here that he's still in progress with. We are experiencing high rate of crime in South Africa, so we need to act with agency so that we cap the corruption as it happens in the country. Thank you so much, Chair.
Thank you, Honorable Mhlala. Honorable Bredenbach, is there any issue you wish to raise before they come for replies? No, Bredenbach. Okay. Mr. Lewis, you and the team, you can now reply in all the issues that would have been raised by members.
Yes, thank you, Chair. I'll do that now. I'm going to leave the whistleblowing questions to be answered when I've answered all the others by Commissioner Kubule Mbeki, who has coordinated our work on whistleblowers. I'll just say we share the committee's concerns absolutely, and she will detail the proposals that have been made on whistleblowing. As I said, we concentrated on institutional architecture in this proposal.
Chair, I'm very sorry, and I don't mean to interrupt Mr. Lewis. Hi, David. I couldn't unmute for some reason, but now I can unmute, and I do have something to say, please.
Okay, Mr. Lewis, can you pause there?
Sure.
At least you were not yet starting with the responses. Still allocating. Honorable Bredenbach, you can come.
Thank you, Chair. So good morning to everybody. I've listened carefully to Mr. Lewis's presentation and I've read carefully through his documents. I'd like to point out to him that at our meeting with him and his colleagues approximately 2 years ago, we were waiting for a draft report that was due then in a couple of months. It was only 18 months late, David, mazel tov. So yes, there are good points in this presentation, and in my view, Chair, what they are proposing is something very similar to what I am proposing. They're calling it a different name and tweaking one or two things. And I want to point out this is not a competition. Okay, and I've never viewed it as a competition. I don't care what we call the institution that is set up. And I honestly don't mind where the credit for it goes. And you know, Chair, that my view has always been that this should be a committee bill. And that the committee should sponsor this piece of legislation. So this Justice Committee, at the end of the day, is the body responsible for setting up the body that will deal with corruption. It seems to me to be the right thing to do. So I take careful note of Mr. Lewis's comments, and let me add that I have high regard for Mr. Lewis. He has a long time in this business, and he's a proven anti-corruption fighter. So I have regard for all of his inputs, as I have regard for him. I think that the members' bill that I proposed was always intended to be the start of a discussion, a way forward, because if somebody didn't do it, it would never get done. So it was never intended to be the final answer to all the questions. And I suggest that we now take away, and I see that Advocate van der Merwe is on the platform, and I must admit that the parliamentary department responsible for this drafting has been so incredibly helpful, so incredibly insightful, that members cannot do their work without them, and I thank them yet again for their inputs. I think we should take all of these documents and go away and consider them offline, perhaps get together offline with Mr. Lewis and his colleagues and other people who have an interest, Mr. Hoffman certainly, who is largely responsible for the core of the bill that I produced, and see how we can merge all of the best points of all of these documents to come up with a corruption fighting body. What is sure is that we need a corruption fighting body. And I hear Mr. Lewis's concerns about more than one institution, and for many years that was my view too. It's no longer my view, because the National Prosecuting Authority is not succeeding in prosecuting top-level corruption, money laundering, and organized crime. They are not honestly, if we're honest with each other, even succeeding at prosecuting the very ordinary nuts and bolts cases. And so to leave things as they are is taking an ostrich approach, sticking your head in the sand and hoping that things are going to get better. Well, they're not. Fighting crime is an incredibly complex procedure. Fighting corruption and organized crime is much more so. To fight crime, you need specialist and dedicated people, just on every level. To fight high-level organized crime and corruption, you need very specialized people. This takes time, it takes money, it takes resources, none of which any of us have right now. Certainly not the National Prosecuting Authority. The SIU model is working, but only to a degree. They have a lot of success. Their funding model is as we all know, Chair, a disaster because their bills are not paid. And so government departments owe them vast amounts of money that can't collect. The expertise that is within the SIU was largely poached, for want of a better word, from the police and the NPA. So what you lose on the swings, you're going on the roundabouts. Nobody wins. We need to address those issues. It's no good being proprietorial about the solution. We need together to find a solution, and we need to find a solution quite soon. Because things are not going to get any better anytime soon unless we do something quite drastic. And it's incumbent upon us, this committee, to do that. How we do it, with the cooperation, assistance, input of civil society, absolutely. This is a time where we need to call upon the very best of everything that's available and sort out this problem once and for all. And so I suggest, Chair, that we take the discussions around the various inputs now offline. We can arrange, not in committee time, but outside of committee time, meetings between the members of the committee and other people. The committee can't do it all the time. We have other work to attend to, but members of the committee and other people who are interested in offline meetings where we put together, try and merge the best suggestions of everybody in this regard, and then come up with another document that is a more advanced proposal of what we have here. But to continue the way we are is really, you know, the definition of insanity is doing the same thing over and over and over and over again, expecting a different outcome. It ain't gonna happen. And we are not winning the war against crime, not even remotely. The other day, we all read in the newspaper, to my intense irritation and disappointment, that AfriForum had prosecuted an ordinary assault case and won. Assault. Assault is the bread and butter of the National Prosecuting Authority. They declined to prosecute. AfriForum took it to court and won. Why? We need to know why. And if the NPA cannot be relied upon to prosecute even a simple assault case, then on what basis do we think that they're ever going to prosecute anything from Zondo or anything else successfully? So really, Chair, this is the time for drastic action, drastic solutions, and we need to get it done. And we need to get it done quickly. It's no good postponing these things for months and months and months at a time. We need to get it done. There must be a sense of urgency. And I suggest that the committee, all of the members, or a reduced group that's nominated by the members, work with Mr. Lewis and his organization, work with Mr. Hoffman and his organization, and other interested members of society, and come up with a document that merges the best of what we have and see if we can take this matter forward. But to continue everybody producing documents and everyone has a critique of the documents, honestly, we're all going to be old and retired and living under that tree that you have with a very bad connectivity that that will be no solution to this problem. Thank you, Chair.
Thank you, Honorable President Bach. That's noted. Mr. Lewis, proceed.
I'll proceed, and I'll say at once to Honourable Breitenbach's proposals that we would like nothing better. I'm sure I speak on behalf of the whole council, than to sit down with members of the committee and talk about, the possibility of integrating these two proposals. And and we're thankful to her for introducing this bill precisely for the reasons that she says, that it stimulated this kind of conversation, which we really need to have. And she's done that, I know, because she's as concerned about corruption as we are. But I will say to her that we will come to that engagement with a view that says that policing powers should not be part of a Chapter 9 institution, and that we do not think a new prosecutorial institution is the answer. We can see why there is a need to strengthen the existing prosecutorial agencies, But we do not think that a new prosecutorial agency is a good idea, precisely for the reason that she gave about the SIU poaching all the best skills in the NPA and the Hawks and SAPs. And the reason that they're able to do this is because an institution like the NPA does not have the autonomy like the SIU does to determine its own salary levels. So we will come to that engagement in absolute good faith and recognizing the value that somebody like the Honorable Breitenbach has made to fighting corruption over her years as a senior prosecutor and now as a parliamentarian. But we do feel quite strongly that there is no agency in the world in which prosecutorial responsibility and certainly policing responsibility is absolutely independent of executive intervention. Certainly there can be no executive intervention in prosecutorial decisions. In the decision to prosecute, to end a prosecution, there can be no executive involvement in that at all. There can be executive involvement in deciding what are the priority crimes to prosecute, but no discussion of particular crimes. But where the police are concerned, where the investigators are concerned, and the private members bill is advocating an investigator-led prosecutorial service, where the investigators are concerned, these should not be beyond executive responsibility, because they're an agency with policing powers, and nowhere is a policing agency independent of all executive intervention. So we would like to discuss this because, I know it's complicated. We're also recommending that there should be investigators in IDAC, and are they beyond executive control? So we would like to talk to the committee about this, and whoever the committee chooses to bring with them, but we will come to them with those. Let me answer the other questions, and thank Honourable Breitenbach for having introduced this bill. And I will leave the whistleblower questions to Commissioner Kabula Mbeki, who has been responsible for coordinating this. But just to say that we absolutely share the concerns, I think, of all the committee members who asked questions about protection of whistleblowers and, question of incentives to whistleblowers, but she will answer those questions. Let me say a couple of things. Firstly, about the question of duplication, which again was something that everybody raised. And we absolutely share those concerns, as I think is evidence in our proposal, because in our proposal, there will be no new addition to the number of institutions that we recommend fighting corruption. We've recommended this merger between the SIU and the OPI. The SIU will then cease to exist in its present form. And the problem with the SIU in its present form, there are two problems. The one is that it has no statutory basis. It's there by proclamation, and it can be ended by proclamation in the same way. So the new agency needs to have a statutory basis, at least. We are recommending it has a Chapter 9 institution, but we need to take your advice on how long that would take and whether that prolongs the process of setting up a new institution. But we recommend it has a new statutory basis. The second thing that is wrong with the SIU, as one of the members of the committee pointed out, is that it must wait for permission from the president to undertake an investigation, and it reports to the president. We are recommending, and this will be in our final report. I think it was in our interim report as well. We are recommending that while the president still will have the power to ask the new agency, let's call it the OPI, to undertake an investigation of systemic corruption. The new agency will also have the power to take that decision on its own initiative. So it will not be a prerogative that belongs to the president alone. It will be, if the new agency wants to investigate the office of the presidency, it can initiate that agency on its own, that investigation on its own initiative. Our view is on the reporting that it may still report to the president, but probably ideally should report on the outcome of its investigations to your committee, to Parliament. Certainly what we will require is that those investigations be made public immediately on a report being issued, and that its recommendations be binding. So if it recommends to Tembisa Hospital that they should establish disciplinary committees to deal with a whole lot of their people, or that they should employ a new method of awarding contracts, then they have to do that, and they have to do that within a specified time period. And if not, we need to talk to people like with the experience of Ms. Breitenbach about how you punish people in that context. And we believe, if you don't answer a subpoena or you don't undertake a remedy that is binding, you can be prosecuted criminally for not doing so. So in our system, there is no duplication of institutions. The one duplication that is mentioned that is of concern to us is with the public protector, and we still have to engage with the public protector. The public protector is responsible for dealing with maladministration. The OPI, in our recommendation, will be responsible for dealing with systemic corruption. These two things they are often gray areas. And my understanding is that the SRU and the public protector have already had to overcome that problem through coordinating with each other. And the coordination mechanism that will include the OPI and that will include the public protector, and maybe a special coordinating mechanism should be set up between them, between those agencies, will decide who undertakes particular investigations. And if a special clause in legislation to ensure that coordination takes place, then it will take place, and it will impose time limits on decision making, and it will impose some deadlock breaking mechanism. But it's impossible to overcome all gray areas. It's just not possible. I mean, how do you understand the difference between organized crime and corruption? Well, there are gray areas, significant gray areas there as well. But they are going to have to be resolved by coordination. To imagine that we can set up some absolutely watertight distinctions between the agencies is, I'm afraid, chasing after a rainbow in this regard. You will never successfully do that. We were asked how we would rate ourselves on the recommendations of the Zondo Commission. Actually, we would rate ourselves quite highly. We are only instructed to investigate the systemic recommendations of the Zondo Commission, not the recommendations to prosecute this person or prosecute that person. That we are not responsible for. And there are a number of new institutional developments that the Zondo Commission recommended. The one was a new anti-corruption institution. All that we've clearly done. The second was a procurement, an anti-corruption procurement commission. We don't agree that there should be specialized anti-procurement corruption institution. We've done a lot of work on how to strengthen the procurement system. And there's no doubt that the OPI would have a division within the OPI dealing with procurement. There's no doubt about that. I mean, most corruption occurs in the context of procurement at the moment. So there would be a unit responsible for dealing with procurement, but we don't believe that there's a reason to set up a special anti-corruption procurement agency. It will be core work of the new agency. The third thing that the institutional remedy that the Zondo Commission recommended was setting up a permanent Zondo Commission. Well, here again, one of the powers that we recommend that the OPI has is to convene public hearings and to compel evidence to be presented to those public hearings. And this will give it the powers of a Zondo-type commission of inquiry. Without a permanent Zondo commission being established, with all the resources that consumed, and I have to say all the excellent work that it did. But we will recommend that the new agency has the power to convene public hearings, to compel evidence being reported to those public hearings. So those are the institutional, if you like, and strategic recommendations that the Zondo Commission made. And so I think we rate ourselves, if we may, quite highly on paying attention to them. We have engaged with Justice Zondo and former Chief Justice Zondo and members of his team in a very fruitful engagement. And I don't think that in substance there's really any difference between what he's recommended and what we're recommending. So that answers, I think, the questions of many of the members. On cost, we have said we are looking at a new funding model. As Commissioner, as Member Breitenbach suggests, the system of getting the public service to pay for is not a good idea. And it hasn't worked. I think the amount owed by the public service to the SIU runs into the billions, and clearly this is not going to be paid. And so, and besides which, I don't think it's right to have the organization that has been investigated by an anti-corruption commission to pay for the investigation. It just somehow doesn't strike me as the right thing to do. I think that we are honoring the court decision in Glenister, which has said there must be adequate independence. It hasn't said there must be absolute independence. It said there must be adequate independence. And I think we meet that. For example, in respect of the NPA, we are recommending, new appointment procedures, security of tenure. We are making a recommendation for a whole administrative autonomy. We are recommending a whole lot of steps that must be taken to strengthen the independence of the NPA, which is what Glenister was largely concerned with, in my understanding. And so I think that we have honored the Glenister recommendations. I recognize, the frustration and the weaknesses of the NPA, and we've engaged in answer to that question extensively with the NPA and the SIU, and they've been extraordinarily cooperative. I think we must have engaged on a half a dozen occasions at least in sort of all-day meetings with the NPA and with the SIU, and they've been very open and very helpful, and they've given an extraordinary leadership time, because I think they recognize that there are weaknesses within each of them that they want to be strengthened. And so we have engaged with them, and we do recognize their poor performance. And we try to address that both by recommending that they may be made more independent, and secondly, by recommendations to strengthen IDAC. As I say, we have not arrived at a final conclusion regarding how to allocate mandates between IDAC and the Hawks. The Hawks, I might add, we've also engaged intensively with, and they've also been immensely cooperative. And we'll resolve this one way or another. But I have to say, even though this has not been discussed by the council yet in formal sittings, I'm personally very interested in this proposal that says, don't set up a large prosecutorial and new prosecutorial and investigating body within the NPA. In other words, make the IDAC a lean, mean, seriously expert body that has seriously expert forensic accountants, seriously expert IT people who understand money laundering. Make this a small organization that could be, that can bring in external resources where it needs them. And that's a system that also needs to be considered. But we believe that it is possible to make the NPA more effective. We don't believe that every time a government institution fails, that there's a reason to set up a new government institution. There is reason to solve the problems in the existing institution. And, one of the things, for example, that the NPA could do is it has the power to delegate prosecutorial responsibility. So, if the OPI and its investigation of systemic corruption comes across relatively minor corruption or non-complex corruption on the part of a particular person in the agency it's investigating, the NPA can delegate the prosecutorial responsibility to the OPI. And, that's something that can be considered, so that it's not concerned with very, very small corruption cases, but it focuses on the larger corruption cases, and they've got to be strengthened in order to do this. So I hope this is not going to be another white elephant. And, yes, the SIU will disappear. I mean, it could be that the new institution is still named the SIU, if you want, and it absorbs the functions of the OPI. We think that a reset is necessary, and that it would be better to set up a new agency, but that absorbs the strengths and the resources and the experience of an organization like the SIU, precisely so that we can short circuit the incredibly lengthy time it takes to get major legislation passed through Parliament, and the extraordinary amount of time that it takes to set up a new bureaucracy. We haven't yet engaged with GTAC and the sort of institutions that need to be engaged with in order to set up a new institution. I'm not sure that they would engage with us until our recommendations were formally adopted by Cabinet or whichever agency is responsible for formally adopting them. But certainly, we're not ignorant of the funding problems, and that engagement will be held. But I'd go out on a limb and say that yes, new resources will have to be provided by the OPI to the OPI, but with the absorption of the SIU, I don't think that those new resources will be prohibitive. They certainly will not be like setting up a new agency from scratch and maintaining the SIU in existence with all the duplication, both of funding and of functions that presupposes. I think that answers. I think that answers everything except the whistleblowing questions. And I'd ask if you would just permit Councillor Gqubula Mbeki to speak about her work in that area. Chair, is that okay?
Yes. Can she proceed?
Thank you, Chairman, and thank you to the members, the honourable members of Parliament, with whom we're meeting here today, and thank you to this committee. The Honourable Glynis Breitenbach says that what is sure is that we need a body. And South Africa is party to the OECD Anti-Bribery Convention, as well as other anti-corruption treaties such as the UNCAC, the United Nations agreement, the African Union ones, and the SADC agreements on anti-corruption. These treaties, every single one of them requires the establishment of an independent anti-corruption body, which became a central issue in the Glenister 2 case, as we've all heard. And that Constitutional Court ruling in the early part of 2011 said that corruption is a human rights issue and an existential threat to constitutional democracy. And we as NACAC have taken that ruling very seriously. So I'm just emphasizing the points of confluence. Yes.
Yeah, you are up properly now. You were very down. You were just at the bottom of your screen.
Okay, I'm sorry about that.
You are fine now. You are fine now.
My eyesight gives me problems, so I'm sorry about that.
Okay.
I was simply reiterating what the Honourable Glynis Breitenbach said about the fact that the only certainty in this discussion is that we surely need a new body. We have already ratified the OECD Anti-Bribery Convention that requires an independent body, and we've also ratified a number of other anti-corruption treaties across the world, including the OECD ones and the African Union anti-corruption treaties, and they all, without exception, require the establishment of an independent anti-corruption body. Further, Chair, I was reiterating the points made by Councillor David Lewis in his emphasis on the fact that both Glynis Breitenbach, the Honourable Glynis Breitenbach, and ourselves have taken to heart and are really eager to meet the Constitutional Court's recommendations in our considerations of the future architecture, and we share the Constitutional Court's view that it's a human rights issue and an existential threat to constitutional democracy. Further, it says that we are constitutionally obliged to establish a body outside executive control to effectively combat corruption in our country. When it comes to whistleblowing, we've walked a very long road. We started with a very research-based approach, even though we also walked a long road with civil society. That means in the marches, in the streets, and interacted with all the significant Zondo Commission whistleblowers one by one, and invited many of them to serve on the NACAC initial reference group on whistleblowing. So with regards to all the different whistleblowers who have helped us get to a point of reckoning with regards to what Zondo recommended. We have not only argued for the establishment of a whistleblower fund, psychosocial support, and worked with Whistleblower House, which provides psychosocial support and legal support to whistleblowers in our country. We have also recommended to the SIU the consideration of security support, and we have spoken to people with regard to witness protection for various whistleblowers in our country. It's a very difficult fight, and as the honourable members correctly point out, the Protected Disclosures Act in South Africa of 2000 offers very scant and very little protection to whistleblowers in our country. Consequently, we as NACAC have not only issued 3 advisories. The first advisory was on the complete and profound overhaul of the PDA, and we are happy to report that in a meeting with the President himself, he agreed with the Minister of Justice that we need a complete overhaul of that. We have also worked with civil society who have begun the process of drafting a civil society private members bill, which they hope will land on your desks. And we would then at that point advocate for the merging of the documentation on whistleblowing. We have had sight of the Civil Society Whistleblowers Bill, and we have worked very closely with the DOJ on every single aspect of the 7 areas where whistleblowing must be amended. And further, we have said that it must come out of the labor relations section of our law and potentially into the human rights area of our law. And Glenister backs us up in that respect. We've identified 7 different things that are wrong with the PDA that lead to whistleblowers' lives being eviscerated and the vulnerabilities being emphasized, and indeed the deaths of whistleblowers. We have even recommended the establishment of a special ombud, and the location of that ombud or that whistleblower protection agency is still a debate between ourselves and the public protector. We have had several meetings with all the parties as to where to locate the whistleblower agency, and my personal view is that it belongs with the OPI or with the independent agency because of the strong constitutional protections that would be afforded to the future OPI. And the SIU, which would become the future OPI if our proposal is accepted by the August House, we would then tuck in the whistleblower agency into that body so that it can enjoy the kind of Chapter 9 protections that it would need. And it would also have a tribunal which you need to look after whistleblowers. We are aware that the DOJ says that the tribunal should be located at the Human Rights Commission. We are at odds on those issues. It is perhaps imprudent of me to mention that our relationship with the DOJ has gone through different moments of intense debate, and yet there have also been moments of profound collaboration. And at the moment, we are at a moment of collaboration, and we hope that we will be able to bring to the House, well, the DOJ would be able to bring to the House a new set of watertight legislation that can better protect whistleblowers. In fact, we believe that the legislation that will come before the House, especially if the concerns of civil society are accommodated by the legislation, will be an avant-garde, a world-leading piece of legislation, and indeed a new generation of whistleblower law. We have looked at the European Directive on Whistleblowing, and our new law will take into consideration all those recommendations in the European Union recommendations. We have looked at the Kenyan law. We have studied East Asian laws on whistleblowing. We have looked at the Hong Kong example, and we have also traveled extensively doing research and spoken to all the parties in the Balkans and in the European Unions who have had to transpose the European directive into their local law. And I'm confident that by the time that the term of office of NACEC ends, we will have made significant strides towards being ready to put that law on the table before you. But we understand that protection of whistleblowers extends beyond legislation, and we continue to argue for interim arrangements where there is an establishment of a fund and an interim judge who looks after the affairs of whistleblowing. I do not want to take your time, Chairman. I am grateful for the opportunity to update the committee on our work and our interim report. Thank you so much.
Thank you very much, Ms. Kubulembeki. The department is working on a whistleblower protection bill. They are still undergoing their internal consultation process before submission to Parliament. I'm sure there's a great input on whistleblower protection can help us when we process that kind of bill as well. I think we have a greater problem in the country that derails the fight against corruption of whistleblowers being targeted as victims on the basis of their whistleblowing. I think that input can help us. So we surely will invite you to make an input in that regard as well.
Okay.
Honorable Mhlala.
May I please follow up on something before you close?
No, I'm not closing. Well, I'm checking.
Oh, okay. No, thank you.
They have concluded the first round. Mr. Lewis?
Thank you, Chair.
Are you done? Are you done settling with the questions?
I hope so. You know, if I haven't answered a question, then please point that out to me. But I think we're through with that.
Okay.
Yeah, thank you, Chair.
Lewis, Honorable Mhlala, you have a follow-up question?
No, thanks so much, Chairperson. I'm not going to take long like before. So my question is on the lifestyle audit for senior public officials and executive of companies that receive public contracts. Why is there no recommendation that speaks to that in your recommendation, Chair? And then the other thing, lastly, as the NACEC term ending in August 2025, what guarantees exist that its proposal will be implemented rather than buried under the weight of bureaucratic inertia? Chair, last. What steps will be taken to ensure that the OPI can reopen historical corruption cases where prosecutions were blocked or sabotaged by institutional complicity? The other issues, Chairperson, like the issue of Phala, we know very well that people that are holding high state position can do anything to block a case for continuing or to be investigated. What is the OPI going to do in terms of those issues? Because we rather face the justice system rather than protecting a person or an individual for being investigated. Go through the justice system, present your case, talk, and then at the end, the law must clean you or must vindicate you from that particular case. This thing of just because I'm powerful, I can be able to stop that process happening. What is the OPI going to do? And what is NACEC recommending in terms of such cases? Thank you.
Members, is that the only follow-up? I don't want us to come back here again. Okay, it looks like the only follow-up question. Mr. Lewis, please attend to that.
Yeah. On the question of lifestyle audits, we have discussed this and not come to a sort of final determination about it. At the moment, I think it's assumed that lifestyle audits would be carried out by the Public Service Commission. We've spoken to the Public Service Commission on a number of occasions and cooperated closely with them on, for example, our national dialogues. They're an important body, the Public Service Commission, in the fight against corruption, largely because they deal with discipline in the workplace, in the public sector workplace. And, the lack of disciplinary measures being applied in the workplace is probably as serious a cause of impunity as the failure of prosecutions. I don't know if I'm convinced that they're the right organization to do lifestyle audits. They certainly don't have the resources and the personnel required to do them. But we think that they're very important instruments in fighting corruption. And it's possible that we may recommend that the OPI/SIU be given the responsibility for doing lifestyle audits. But these are important measures. The same goes for financial disclosures. Who will be responsible for compelling and receiving financial disclosures? I saw a really embarrassing slide the other day which indicated what the key elements were for enforcing financial disclosure mechanisms. Comparing Southern African countries, South Africa was the only country that had not completed one of the measures necessary to compel and enforce public disclosures. Lesotho, Eswatini, Botswana, Mozambique, all of the others had completed at least some of them. Some had completed all of them. South Africa has completed none. And these are important things to look at. I mean, we can't force implementation of our recommendations. You're in a much more powerful position to do that than we are. So we will hand our final report to the president at the end of August, and we will hand it to you. And I hope that you're able to compel the decision makers to take the report seriously. That's really all we want. But there is nothing we can do about it. And I don't think that there's anything we can do about reviving corruption cases that have not been successfully prosecuted. That again is beyond our powers and knowledge, I guess. So we can't do that. Only the NPA can do that, really.
Thank you very much, Mr. Lewis. I think it's worth mentioning that if from the executive part of the arm of state agrees on the establishment of the Office of the Public Integrity as a Chapter 9 institution that will require a constitutional amendment, and the only arm of state given powers in accordance to the Constitution to enact laws is the legislature. So we'll attend to the nitty-gritties of the OPI. If a bill is introduced to Parliament in establishing the OPI, we'll attend to the details of it. It sounds promising on paper. We are going to look into it. And of course, Parliament will deliberate on it and enrich whatever would have been submitted by the executive. I think I've taken note, as I said, that we have strong submissions on the whistleblower protection, which is one of the current problems the country is battling with. Whistleblowers are assassinated in all corners of society. And I think as the state, we bear an obligation to protect them. But also, as I mentioned before, that we are coming to that, sorry, to that as well, as the department is still trying to collate information relating to whistleblower protection, and will introduce a bill to Parliament. We therefore will attend to that in detail to ensure that we cover all the necessary aspects to protect our whistleblowers. I think we all are enjoined here by a common vision to ensure that corruption is fought to the end. It's just a matter of developing proper mechanisms to ensure that corruption is eradicated from both the public and the private service. This is the exercise, Mr. Lewis, that we've been undergoing, having conversations with those that which we think the contents of the bill actually directly affect them, as proposed by Advocate Breitenbach. We thank you very much for having made this input. We know that we were supposed to have had this conversation a month or 2 months ago, but there was an indication from the department of some loose ends that need to be tightened. We had to postpone you. We thank that you were patient and were able to come to the committee meeting to enrich what we are trying to do, which is a serious revolution of eradicating corruption in all sectors and portions of our society. We thank you very much. We have no doubt that this which you have tabled to us today will help us navigate through this objective that enjoins all of us in the fight against corruption. We are going, members, to have a day where we're going to deliver. We know what Advocate Breitenbach has raised of maybe an offline consultation. We'll look at that. We'll therefore, as a final stage of this kind of consultation, to determine which way are we taking. We'll have a meeting to deal with both bills. Today, we were dealing only with the 21st Constitutional Amendment. We also have done consultations with the 20th Constitutional Amendment Bill. So we're going to deal with them both, deliberate as the committee in both of them at once, and adopt a motion on desirability of these bills, both of them. So thank you very much, Mr. Lewis and the team from NACEC for coming to the committee and enrich our deliberation or our consultative process in ensuring that we navigate through the proposed constitutional amendment. Then we'll step off this meeting. We'll excuse you or recuse you, NACEC. We'll be taking the Magistrate Commission now. Thank you very much.
Thank you, Chair, and thank you for this opportunity. And we really look forward to more engagement with the committee. I really hope that that happens, and we both look forward to that. Thank you very much. Goodbye.
Thank you. Thank you very much, Mr. Lewis. Committee Secretary, who from the Department of Justice is in the meeting? Is the Deputy Minister in the meeting?
Chairperson, the Magistrates Commission will be doing the briefing.
Is there anyone from the Department of Justice?
Yes, Chair, I think the DG is also here.
DG, are you here?
Chair, I'm here, but I'm waiting to be called to a meeting of cabinet, so I may disappear at some point.
Who else from the department is here?
The Secretary of the Magistrates Commission, Mr. Justice Fingers, is here, and Deputy Director General Khalid Pillay, though she was here for the other item, she might leave as well. Mr. Malisela from my office is here, and Tabisile Mahlangu. I see Zoleka from the Minister's office is in as well.
Thank you. Thank you, DG. That's noted. Do we have the chair of the commission? Or rather representatives of the ethics committee?
Good morning, Honorable Chair and Honorable members. I'm Naomi Manaka. I represent the Ethics Commission and the Commission, Ethics Committee and the Commission. Thank you.
Are you alone?
I'm the chair of the, I'm with Mr. Finger. Yes,
Okay.
Today I'm alone, Honorable Chair, because the meeting was moved from next week to today, so we couldn't get members relinquish their activities to attend at short notice. Thank you, Chair.
Okay, we hope that we'll be able to handle the deliberations coming from members. I see that you have got about 6-7 magistrates that are part of your report.
I have two. One is for provisional suspension. The other one is for permanent removal.
No.
Those are the
No.
two. And then the other ones, I suppose, is the report.
Yes, you are dealing is the report that is going to be deliberated by these members. So you don't have two. You have 3 categories. You don't have two. The other category is for suspension. The other category is for removal. The other category is a report on progress. Yeah. So members are going to interact with all the categories.
Yes, I'll try on the third category. I've asked Mr. Finger to prepare on that category. I do have facts to a certain extent and will engage.
Right. That's why it's important for us to ask who is here, because we would not want a situation where the commission is here but can't provide answers into what the members are raising. So that's why it is important for us to ask who's here. Okay, let's proceed with the report then.
Which one should I proceed with first? Is it Kekana, the suspension?
Proceed with everything, ma'am.
All right. Thank you, Honorable Chair. I will start with the matter of Kekana, which is the matter relating to the suspension, provisional suspension. Ms. Kekana is a 55-year-old magistrate who's sitting in a district court since November 2015. The allegations against Ms. Kekana is that she does not submit weekly and monthly statistics, that she does not comply with office hours, and most importantly, that on one occasion she had met litigants within the court buildings and later in their business premises, attempting to negotiate a mediation between the parties with those particular complainants. Ms. Kekana has been charged with misconduct. Based on those allegations, the charge sheet was served on her. The other allegation against her is that she removes matters from the court roll without holding a proper inquiry in terms of Section 342A of the Criminal Procedure Act and struck them off the roll. Based on that, the commission resolved to charge her with several counts. The provisional suspension letters were given to Ms. Kekana on 27th of May 2024, and she was also requested to furnish reasons why she should not be placed on suspension on 27 June 2024. It is for that reason that the commission pleads with the honorable committee members to consider placing Ms. Kekana on suspension pending the outcome of the misconduct hearing. The second matter is the matter of Ms. Kavenda from Linyenye. Ms. Kavenda's allegations have been placed before this committee before when we were moving for the suspension. The matter is on the agenda for removal of Ms. Kavenda. Ms. Kavenda is a magistrate in Linyenye appointed on 1 Feb 2018. The allegations against her is that Ms. Kavenda presided over a matter and changed the plea of the accused without following the proper processes. The matter was taken on special review, and questions came from the Honorable Judge Kanyaho as a reviewing judge relating to the processes that she followed, and Ms. Kavenda misrepresented the facts to the judge. The judge made some damning remarks against Ms. Kavenda of dishonesty and referred the matter to the commission for inquiry. An inquiry was held. A charge sheet was completed against Ms. Kavenda in August 2023. She then failed to attend the misconduct. She has been on suspension, having been placed by the minister following this committee as well as the NCOP finalizing and approving her suspension. She has been found guilty of those misconduct of dishonesty. The NCOP in its sitting in April approved her removal, and the matter is before this committee for approval of her final removal from office. Then I will hand over to Mr. Finger, the Secretary of the Commission, to continue with the report, the update, and I'll assist in the answering of the question during questioning time. Mr. Finger.
Mr. Finger. Where is Mr. Finger? Committee Secretary, can you check if Mr. Finger is still on the platform?
And yeah, he tried to call me, Honorable Chair. Can I try call him and find out if there's an issue?
Yes, okay, you can.
Thank you. Chair, thank you so much. Mr. Finger is back on the platform. He will take over.
Mr. Finger, proceed.
All right, thanks, Chair. I was kicked out for a while, but I'm back. Good morning, Chair, to the members and you and
Mr. Finger. Mr. Finger. We see you now. Although there is
All
a
right,
huge,
okay.
there's a huge light on your back, so it will be wise to just switch off your camera. We just wanted to see you. We don't want to sit here and
Okay,
all
okay,
along
Chair.
we're talking to robots.
Yes, yes.
Yeah, you can switch it. You can switch your camera. Proceed.
I have, Chair. All right, Chair. I think you know the report obviously details the history of the matter. I would really, I think, because we report quarterly, just to give an focus much on what is the latest on each matter, if with your permission. The matter of Mr. Nzimande, the regional court president in KZN, as you know, he was suspended in 2018 already. And the matter took, you know, a long time for it to get off the ground due to various people, either leading evidence of presiding officers that had to, you know, withdraw or recuse themselves. It eventually proceeded, and after the appointment of a retired judge, Judge Shongwe. What has happened this year is that last year we moved quite a bit, and we had about 14 witnesses already that have already testified. This year we had an unfortunate situation where the judge unfortunately fell ill, and we have not set, we've postponed it a couple of times, because what we had then resolved was that at least every month
We lost you, Mr. Finger. Mr. Finger. We have lost Mr. Finger again.
Chair, Honorable Chair, let me try contact him again.
Yeah, okay.
Chair, my apologies. I've tried another connection. I hope this one will be stable. Can you hear me?
Yeah, it sounds better. You can proceed.
All right. Yes. So I was at the point where I was saying the matter of Mr. Nzimande will only now proceed from the 2nd until the 6th of June. We had to accommodate the judge's request, so it will be a virtual hearing. The whole team, that is both legal teams, will be in the Point Court in Durban, but the judge will be sitting at his home, you know, so that at least this matter, we just came to this arrangement so that at least the matter can proceed. So that is where we are in terms of matter of Nzimande. The second matter is that one of Mr. Mkanzi. You would know that he was suspended basically for defeating the ends of justice. This is for communicating with an accused in a matter that he was presiding in. And as I said, you would have seen the history of this matter where, since he was suspended, the hearing proceeded, and at some point it stopped because it took us for a review. And from Secretary's office and the Ethics Committee, at some point we then restarted the matter because we felt a review should not stop this matter. He then, when we resumed the matter, went to court to prosecute the review because it was dormant for some time. Unfortunately, the presiding officer agreed with him that the matter should, stay in abeyance until the review is finalized. Fortunately for us, on the 17th of February this year, the review was dismissed by the High Court. That was the review. It was basically reviewing our decision to charge him. So that was dismissed. He also had a criminal matter that was ongoing against him, and that was also finalized in April, where there's an imposition of a sanction of 120,000 or 5-year imprisonment for him. And in terms of the disciplinary hearing now, the matter has been postponed to the 18th and 20th of June. You will see that he basically did not attend the hearing, so we proceeded in his absence after the presiding officer was satisfied that he was properly served. I think but maybe I'll come to the issue of what the Ethics Committee has decided on these matters recently at the end. Let me then just go to the matter of Mr. Naya, the Chief Magistrate Pretoria that was suspended. You would recall that it was basically for work that was done at his home by a company called Bosasa. The matter has had various challenges in the sense that the magistrate that was presiding on it was elevated to a judge in the Western Cape. So he could only assist us during recess, and that delayed the matter. However, the commission was able to present their evidence and close their case. So at the end of the commission's case, they decided to apply for what they call absolution from instance. And the whole argument, I think it took some time. They made their presentation, we countered. Eventually, in April, that is last month, the presiding officer issued a ruling to say there is no provision in the regulations for absolution from instance, and dismissed that application. What we've been trying to get from the other party now is to set the matter down again. I must say we're having some challenges there. Even as I said last night, the legal representative are of the view that they need to consult with their client. We hold a different view, and I think it's really just a matter of us setting down this matter now. We'll I think very soon just set it down for a hearing again so that it proceeds. So that there was no date because of that application for absolution from instance. The matter was postponed sine die. Now let me just go to the next one of Bodlani. Ms. Bodlani also a long history. What happened was that eventually the matter proceeded to a hearing. You would see in the report that in the first instance there were some objections from the legal representatives on this matter proceeding. Later on, there was a change of a legal representative from Ms. Bodlani. But all of those, I think, were able to overcome. The last action from her side was to ask for the recusal of the presiding officer. And really, the application was just really based on the fact that the presiding officer at some point provided I think she was we've got SAJE, the College for Judicial Officers. So the presiding officer at some point was a tutor. So she raised an issue that she may be conflicted on the basis that the presiding officer at some point, provided some lessons. We, of course, as the commission, did not feel that's a strong point. Unfortunately for us, the presiding officer decided to recuse herself. We have now replaced the presiding officer, and the matter is proceeding this week in KZN. The team is already there. That is 15 and 16 May. So we replaced the presiding officer with another experienced regional court magistrate. And I think it was just really the issue of diaries. That's why from the date of recusal, and we could only get the date of May. But like I said, the team is in KZN as we speak. The matter should proceed. The other matter is the matter of Mr. Sin. And I think from the report, you can obviously get an idea of what are the charges. These are very serious charges of him, for example, being involved with crime intelligence. I think we've reported on this before, threatening journalists and all of that. This one, Chair, I must say it's a bit of a challenge for the Commission. You will see in the report that we first tried to have a pre-trial conference. That really just became a shouty match. Our team was really shocked, at what transpired. We had to postpone the pre-trial, and then eventually we decided to let go of the pre-trial and just set it down. However, that also did not assist. Mr. Sin was just, causing disruptions. And it eventually culminated in the last meeting where, and we really had thought that, the presiding officer was really moving on this one, because you would see in the report, there were so many preliminary points that were raised, but eventually the presiding officer issued a ruling in January to give him a specific date to say, look, you need to put all your points in limine or preliminary points, send them to the commission, let them respond. I am not going to entertain any preliminary point in the next hearing. But unfortunately for us, the presiding officer in that hearing, the last hearing in March, unfortunately decided to entertain the preliminary points again, although Mr. Sin did not comply with his ruling and set them in writing. So he then applied for his recusal at the last hearing. And the reason really was to say the presiding officer at some point was a judge appointed as an acting judge under DJ Pilidwaba, whom, as you know, is the chairperson of the Magistrate Commission. So in essence, you are saying because you've acted as a judge under him, you therefore be conflicted. We obviously oppose that. Unfortunately for us, again, the presiding officer decided to recuse himself, which is unfortunate for us. We did not see the need for us, but it's not something that is under our control. What we then did, the ethics committee resolved that perhaps we should look for an acting judge to sit on this matter, because you would know that Mr. Sin, and unfortunately, I don't think we put it in the report. He has also lodged a misconduct against our chairperson for some reason with the Judicial Judicial Services Commission. So he has lodged a complaint against our chairperson, and he has on various occasions indicated that he would like a judge to preside on the matter. Ethics Committee resolved in their last meeting that we should look for a retired judge. Unfortunately for us, we are on the third judge now who has turned us down in terms of proceeding with this matter. So it is something that our chair is looking into it in terms of finalizing the appointment of the presiding officer. But that is where we are in terms of the matter of Mr. Sin. Advocate Manaka, I don't know if you'd want to touch on the issue of the decision of the ethics committee that in terms of, because there was a concern on the money that we're paying on all these officials. Thanks, Chair. I think I've covered all the suspensions.
Thank you. Advocate Managa.
Thank you, Chair. It was before the appearance in the select committee in April that the ethics committee had its cleanup meeting, as we call it, a weekend before, of the 12th and 13th of April. And we really considered the amounts that have been spent by the department in paying magistrates who are on suspension. And we also took into account their conduct during the suspension, as well as other factors relating to whether or not it is still in the interest of justice to pay them. Their factors vary. And having discussed the matter, we resolved as the committee that we should invite the 4 magistrates, I think 3, Mr. Botlani, Mr. Nzimande, and Mr. Mkanzi, to give us indication, or to give the commission an indication why they should still be paid. Their suspension should continue with remuneration. EXCO is to sit on those matters and approve them on behalf of the commission, and as soon as we get the response, we'll take appropriate action. The letter was not sent to Mr. Nair because his disciplinary hearing is almost at the end, and we found no conduct, at least as at this time, that could have delayed the proceedings that justifies an immediate action. So it's Mr. Singh's. So the other 3 magistrates, those letters are sitting with EXCO for decision. Thank you.
Thank you. How often does the ethics committee sit to consider a matter per year?
So
No, proceed.
We have a timetable as EXCO, and Mr. Finger will clarify it because he's the one who's the custodian of that timetable as the secretary of the commission. But to my recollection is once or twice a month, depending on any urgent matters that requires EXCO's attention. And I'll make an example. Yeah, I'll make an example with the ethics committee. So we have a timetable where we meet once a month, virtually, and we have a cleanup meeting, which is 2 to 3 days. Those weekend meetings.
No, Advocate Mana, I'm talking about to consider a misconduct, not for housekeeping issues.
All our meetings are to consider misconduct matters, Honorable Chair, and I'm making an example with the Ethics Committee because from the cleanup meeting that was in April, our next meeting was supposed to be in May, sometimes I think next week, but we had urgent matters for consideration, like to authorize the letters that have been drafted in these very matters that I've mentioned. And we have since met twice to do those considerations and other urgent misconduct matters that needs to go out. So although we do have a timetable, but ad hocly we do meet in order to consider extremely urgent matters. And with EXCO it's the same.
Does it often happen that you meet once a year? Consider a particular matter?
As the committee or as EXCO or both?
The ethics committee to attend to misconduct issues and inquiry. There's no case where the ethics committee only sat once in a particular year to inquire on a particular misconduct case.
Well, there are 2 questions built up in that. Whether we sit and consider a specific matter is one thing, but whether we sit routinely to consider matters, no, it has never happened that we meet once a year, not at least in my tenure as the chair.
Okay, members, can we interact with the report? Just recall that we've got 3 categories members. The category that relates to, I think it's 5 magistrates, 5 or 4. Mr. Finger, is it 5 or 4?
5.
Yes, there is a category of 5 that relates to an update to Parliament in terms of the inquiries that are still underway. So they are reporting to an update to Parliament in accordance to the Magistrate Act that requires them to submit progress reports every 3 months. The other category is the one of Ms. Governor, whom they are requiring or requesting that or proposing that or submitting that she must be removed from office. Their inquiry has concluded, including the NCOP has already dealt with the matter. Then the other one is also we are to decide on the removal of Ms. Governor. The other one is the one of Mr. Kekana.
It's a miss.
It's a miss. Is it not
Yes.
Is it not Mr. TF?
It's a
It's
miss.
a miss.
It's a miss. Okay. Sorry about that. So it's Miss TF Kekana, whom they are submitting that we confirm her temporal suspension. Members, you can come now. Honorable Mhlala, you are number 1. Honorable Nomasonto Mtawung, you are number 2. Honorable Oscar Pretorius Matafa, you are number 3. Honorable Mhlala?
Does
can-
Honorable Klopper and myself not count at all, or we're also going to get a turn sometime, Chair?
Sorry, I didn't see you, Honorable Bredenbach. I am still not seeing you in my list here. Okay, you are going to be the last one. I don't know what's happening with my...
Turn right onto Franz Conradi Drive.
Hi. Who is
you again.
navigating in Cape Town? Okay, you are going to be the last one, Honorable Bredenbach. We are noted. Honorable Mhlala, proceed.
No, thanks so much, Chairperson. Let me take an opportunity and greet the Portfolio Committee members once again, and also extend the greetings to members representing the Magistrate Commission. Chairperson, we received the report, but I will start by saying that it is really very discouraging, where you before we can state whether we support or not support, there's issues that we want to raise here, which we are not happy of, where it shows that the briefing note reveals that over 31 million has been paid out in salary to suspended magistrate. Some of them are since from 2018, with some individual suspension lasting more than 5 years. This is a direct transfer of public funds to individuals not delivering any service, while communities suffer from court backlogs and delayed justice. So, Chairperson, there's a question that I want to ask with regards to that. Why has the Commission failed to use its powers under Section 13(4)(a) and B of the Magistrate Act to reduce or withhold salaries of magistrates suspended for years, despite clear provision and mounting public outreach? Will the Commission commit to immediately implementing salary reduction for all suspension exceeding 12 months? And if not, why does it continue to protect the financial interest of the few over the needs of many? Chairperson, I think there must be a legislation in place that speaks to people that are getting money from the public purse, of which they are not actually doing the work. It is very wrong, Chairperson, for a person to be suspended for over 5 years, earning from the state purse. This is really very out of order, and we're not going to tolerate it as this portfolio committee. There must be something that we can do in that regard. There must be a time limit where we are saying up to here, it stops. We can't be paying people sitting home, dragging us every day when they think of just delaying the case, changing lawyers and everything. And the other thing that I want to also emphasize on, Chair, this thing of recusal of magistrate, we need to come out as well with something that will ensure that magistrate, they don't just recuse themselves easily, unless if it's really of a reason that all of us can say that the magistrate can recuse. Because in one of the cases I saw there, some magistrate just recuse them. When the case is about to sit, the magistrate recuse herself. We start the process again. That thing must never happen, Chairperson. We are actually destroying the finances of this organization. And all those magistrates that have been benefiting from this process, I think there must be something that we do. They must return our monies back. We cannot allow to be paying people sitting home and doing nothing. Another thing is with us as well as the Magistrate Commission. Chairperson, in some instances, is the Magistrate Commission, I think you asked a very clear question when they were presenting here. How many times is this Magistrate Commission sitting to deal with some cases? I've got a case that I reported, Chairperson, of a magistrate in the eastern, in Gauteng, I think. The magistrate who also, according to the person who brought the case forward, the magistrate is abusing his power, is conducting himself in a manner that is not supposed to be, conducting himself. We brought the matter to the Magistrate Commission. Today, we are still suffering to get exactly what is the Magistrate Commission. Every week, I'm speaking to Justice Fingers. What is happening? Nothing is happening. We did not sit. We did not have a quorum and all those things. This is us as Magistrate Commission. This is this entity called Magistrate Commission that is sometimes delaying the processes of dealing with issues. Chairperson, we are requesting that these matters that we are bringing forward to the Magistrate Commission, they must act with speed, because it's the taxpayers' money that are paying these people, this magistrate, that are not actually working to deal with issues. Instead, they are enriching themselves, they are doing wrong things. We cannot allow that to happen. Chairperson, the briefing also admits that several magistrates resigned as soon as they were charged, effectively escaping the consequences of their alleged misconduct. These loopholes allows those accused of wrongdoing to evade justice and potentially resurface elsewhere in the public sector. So my question is, what legislative or policy changes will the Commission advocate to ensure that resignation does not terminate disciplinary proceeding or accountability? And will it support the creation of a public register of former magistrates who resigned under investigation to protect the public from repeating offenders? Once more, Chairperson, the Commission claims that it has adopted the standard operation procedures and completed a backlog audit only in February 2025, years after the crisis began. This reactive approach is insufficient for restoring public trust or delivering justice. Why did it take years for public and parliamentary pressure for the Commission to adopt basic standard operation procedures and conduct a backlog audit? What guarantees can the Commission provide that these measures are not just window dressing? And how will it ensure that the standard operation procedures are enforced with real consequences for non compliance, Chairperson. And lastly, Chairperson, I want to emphasize on the issue that I brought forward now of a complainer who complained about magistrate in the magistrate court of I think it's in Gauteng. I'm not going to mention them by name, but can Justice Fingers please respond to that issue as soon as possible? Can it be given an attention it seeks to attend? He knows what I'm speaking about. We cannot delay anymore. We must never allow the magistrate to act as if they are above everyone. So the magistrate must be held into account. We cannot allow the magistrate that connive with the accused. All those cases that have been mentioned here, Chairperson, we really support any magistrate who connive with the accused. The system must deal with, the justice system must deal with that magistrate without any delay. So, let's also protect the integrity of this institution called the judiciary by delaying this court cases or this disciplinary proceeding. We are actually damaging the integrity of this judiciary system. We are also as well, sometimes, because we're not giving these people the justice they deserve, we are also damaging the reputation of those magistrates, because we don't know, they have never went through the justice processes to prove if they are guilty or not guilty. So let's make sure that these things, we push them with speed and we don't delay. We need to have the Magistrate Commission that is having teeth to bite. If we have a Magistrate Commission with no teeth, we're going to find ourselves in this platform where we are now having to spend a lot of money on things that we're not supposed to spend. So thanks so much. I will end there, Chairperson. But with anything that went through the proceedings of the disciplinary proceedings, we support them. Let it happen, because we cannot allow corruption or thuggery exist in the judiciary. Thank you.
Thank you, Honorable Mtau.
Thanks, Chair, for the opportunity. Chairperson, dealing with issues of ill discipline and unethical behavior, especially by judiciary officials, on corruption, amongst other things, there is a need of working together in order to achieve the expectations of our community. More in particularly in the administration of the justice. Chairperson, we respect the fact that the commission is independent in their work that they are doing, but I'm concerned about the delay in finalizing disciplinary processes against judiciary officials. Your pace is still very low. Most of them, they are the cause of case backlogs. The cost incurred by government in paying their salaries every month, while there is no service delivery on their part. Honestly, we are not going to take it kind, Chair. When you check the recent report on the select committee, I think that one, Honorable Moshala have already spoke about it, on the rate of the magistrates that are resigning. Based on, especially the ones that they are now being charged. For example, Chair, when you check the case of Mr. Nzimande, he has been on suspension on a full pay since 2018 at the cost of 8 million. When you check the recent or the latest report of the commission, Chair, it's indicated that Mr. Nzimande has notified the department that he will be retiring at the age of 70. My question is, how old is Mr. Nzimande now while we are still tracking on his case? Thanks, Chair.
Thank you, Honorable Matava.
Thank you, Chair. Let me thank the Magistrate Commission for the report and join other honorable members, Chair, in raising a concern about the slow pace in which the Magistrate Commission is dealing with these issues. Whilst we understand that this is not a simple process and it has a lot of intricacies and trickery that those that are accused can play to ensure that the matters are dragged, I wish to align myself with the views of the select committee as emphasized by Honorable Musala to say where there is justification, salaries must be withheld. Because, Chair, one of the responsibilities we have as public representatives is to ensure that the state purse is protected and the limited resources that we have are used efficiently and effectively with the desired impact on society. Because having magistrates sit at home and such amounts and yet we're sitting with backlog cases, it's a problem. And for me, it is a concern. So I think that we need to raise sharply on that one. But Chair, where Honorable Mtaung is correct is that we need to also look at the functioning of the commission. And maybe as a committee, we need to also implore the minister to use her executive authority of either requesting the Magistrate Commission report on itself, whether is it functional. If it is functional but there are dysfunctional members, there must be intervention. If it needs be, the minister must reconstitute the Magistrate Commission. Because, Chair, I'm raising this having tried to peruse the act that brings life to, or that gives life to the Magistrate Commission. I did not pick up any provision in terms of how to remedy the dysfunctionality of the commission. Because if there is persistent unattendance, lack of quorum, one can immediately assume that there's dysfunctionality, and that calls for concern, and it must be remedied. So my view is that we need to find a situation where the Magistrate Commission itself state whether is it functioning optimally or they require any kind of assistance. Or alternatively, they must state what are the weaknesses and how can Parliament, through the committee and the ministry, assist in strengthening those particular areas where they are found to be impediments to the successful execution of their tasks. Chair, on the issue of the presentation on Magistrate Govender and Kekana, I think that if the Magistrate Commission is satisfied that they have done everything necessary, and the only logical conclusion they arrive at is that these particular actions as recommended be supported, let us support those particular recommendation. Because if you listen to the allegations against Magistrate Gegana, they are very serious. And if not left attended, it will bring the entire judiciary into disrepute. That you have a magistrate who just goes rogue and ignores all the provisions and all the laws which govern how magistrates conduct themselves and interact with the judicial system. So I think that we also need to support the integrity, or protect rather, the integrity of the judicial system by ensuring that those that undermine it are actually dealt with. But Chair, in conclusion, we need to take a serious look at the functioning and the ability of the Magistrate Commission to execute its task. If there are failures, let those failures be communicated to us and let us see how we support. And if there are no failures, it's just a matter of dysfunctionality, there must be intervention to that regard as well. I will pause there, Chair. Thank you very much.
Thank you, Honorable Breitenbach.
Thanks, Chair. Yeah, I align myself with the comments of the previous members. And, you know, we get these reports from the Magistrates Commission and say they're progress reports. Well, in fact, are reports of no progress. Because we get the same report over and over and over again, and there seems to be very little movement. And that should be a matter of grave concern to all of us, Chair. And I think we perhaps need to revisit this issue, as Honourable Matafa has already mentioned. You know, the matter of Mr. Naya must be well over 10 years old now. Well over. It's inconceivable. So it's not satisfactory. We're not seeing enough movement. We all understand the difficulties. But a disciplinary process is not a criminal trial. And there should be a lot less latitude for Stalingrad tactics. And so something must be done. I agree that magistrates shouldn't be, or presiding officers shouldn't be recusing themselves for no reason at the drop of a hat. There are very distinct guidelines for recusal. The mere asking for a recusal does not mean that it should be granted. And these issues perhaps appears to be the case. So I think we need to, as a committee, interrogate these reports a little more carefully, look into them with a bit more detail, and at the next sitting with the Magistrates Commission, you know, perhaps provide them with those things that we're not happy with beforehand, so they can come and address us on those, because this is getting us nowhere. I agree that I support the two suspensions as set out in the report. And don't forget, Mr. Klopper's hand is also up. Thank you, Chair.
Thank you, Advocate Managa and Mr. Fingers. Can you react on the issues raised by members?
I think the Klopper's hand is still up.
Oh, sorry. Honorable Klopp, I didn't see your hand. Apologies for that. You can proceed.
Oh, no problem, Chairperson. I thought you're very upset with me today. Chairperson, seriously, you know, 31.31 million has been paid to officials that are on suspension, and I mean, it has been mentioned, so I don't want to really to elaborate too much, but I'm just trying to get more clarification on why they aren't invoking the Section 13(4) and B of Magistrates Act. And it's not necessarily, you know, while they're investigating to withhold the whole salary, but I mean, at least a reduction considering 31 million has been paid out and the length of these disciplinary inquiries are going on. I just need some clarity, please, if possible, Chair. If these magistrates are found guilty, is there a process of recovering the salaries that were paid out on suspension? And I'm asking specifically, was Mr. Mkanzi paid a fine of 120,000, but he received 7.36 million while he was on suspension. So it's just so that I can better understand it. And then is there anything in place to try and fast track these disciplinary inquiries, considering this amount of money? Thank you, Chair.
Thank you very much, Mr. Klopper, Advocate Manaka, and Mr. Fingers.
Thank you, honorable members, for all the questions. Very difficult questions, of course, which do not have straight answers, most of them, but legitimate concerns have been raised, and they're always raised. And perhaps before I deal with the specific question,
I have asked you if you will cope alone with these, with the kind of interactions when we were starting.
No, I will. Mr. Finger is there, and most of them fall within my portfolio. So I'm saying they're difficult because they're real questions. Not that I don't have, I can't answer them. I do think that I'm best suited to attend to most of them, and Mr. Finger will assist as a secretary because we normally work hand in hand. Honorable Chair, I wanted to perhaps give an outline before I deal with the questions of the commission itself, because a concern has been raised about the functionality of the of the commission, and a concern has been raised, and we hear this concern over and over again, and we don't take it lightly about relating to the delays in dealing with matters. And perhaps it will assist members to understand that in the scheme of things, the ethics committee is the one that is seized with most of with all of the disciplinary matters in the commission. And the commission has other committees that deal with other matters pertinent to the commission as a statutory body. But insofar as disciplinary matters are concerned, it is the ethics committee for which I am chair. And members who've been part of the previous portfolio committee will recall that we have made several undertakings, at least as at our first appearance following 2022 thereabouts, which is when I think this committee was appointed and started to effectively operate. And most of the undertakings that we have made, we have actually those commitments we actually came across at some point challenges which we communicated, but in other instances we actually complied with our own undertakings and exceeded them. All members of the ethics committee are not full-time members of the commission. They are legal practitioners mainly, and some of them are magistrates. And I think this year we have a politician sitting in the committee. But because we are not on a full-time basis, we try to come up with a schedule that will work and that will see that the objectives of the commission are met. The commission receives at least over 200 complaints annually, sometimes 300, sometimes 350 per year, that the ethics committee has to process at any given time. And some of the complaints, as we indicated in our previous sittings, do not have merit, but we still need to process them in order to give a hearing to someone who took their time to approach the commission. And I dare say that some of the complaints are directed at the commission recently because of the movements that we make. They are not even complaints relating to magistrates, but because there is some movement of the commission dealing with complaints, people do believe that their complaints are well seated with the commission when in fact they relate to either the clerk, the prosecutor, and the like, and we still need to process them and inform the complainants accordingly. We have made some good strides. The commission has been in existence for quite some time. It has been struggling in terms of members and ethics committee, ethics division members who assist with processing of this complaint within the commission. It was understaffed, and we've dealt with that. It's no longer an issue. But I can assure the committee that there are serious strides made, and we clean. You know, there's many problems, and we cannot clean them over a period of 1 day or a month. But I mean, we have made some progress. The 31 million is a consent. It has been raised, and it is the commission that volunteered that information to the select committee, so that we are transparent as the commission to show that despite our shortfalls and our shortcomings, we still want to be transparent to the public as to, well, we have challenges insofar as processing some of the disciplinary hearings, challenges some of which are not dependent on the commission. They are dependent on the evidence leaders, they are dependent on presiding officers, and not necessarily on the delays that are caused by the accused magistrate in certain instances. And therefore, there is nothing much we can do, because we do not want to affect the integrity of the process by interfering unduly with the decision, for example, of a presiding officer who believes that a case has been made out for the particular magistrate to get a postponement, like in the Mukanzi matter, where the commission was hell-bent and argued against the postponement pending the review, but the person presiding decided that they are going to give a postponement pending the review. There is nothing that the commission can do about that. There is something the commission can do about the delays that are caused by the specific magistrates, and a question has been raised recurringly by several honorable members about why haven't we implemented the statutory provision that empowers the commission to either withhold the salary and or reduce the salary. I cannot speak for the previous commissions, but as at the times that we've been sitting as the committee, we've been trying to find ways of withholding salaries where we believe that a magistrate is the cause of the delay in finalization of the matter. For example, previously before this occasion, Mr. Mukanzi, we at the committee level, at the ethics committee, we resolved to inquire from Mr. Mukanzi why the committee should not recommend to the commission that his salary be withheld because he was the cause of the delay. And when Mr. Mukanzi responded to that correspondence, he advised the committee that not all the delays were caused by him. At some point, it was the evidence leader who was not available. And at that point, we couldn't act accordingly. But now we do have sufficient grounds and we are acting accordingly. And indeed, we've erred in the past as the commission, and it's because there's just so much to do, and we're trying to fix so many things. And some of the things, of course, will slip us as the 31 million rand. Perhaps if it goes every month, it doesn't look much. But as soon as we realized that there is just so much that is being spent, we did an introspection and we decided that we need to act accordingly. So I'm going to then try with that background to deal with the concerns raised. And please, if I miss any consent, I'll be happy to attend to it after this. Whatever I leave out, I'll defer as well to Mr. Finger, who may have more knowledge than I do as the administrator. The age of Mr. Nzimande, he's about in his 60s, and Mr. Finger will give the exact age, and that's why he's applied that he will leave at the age of 70. But as I have mentioned, we have already informed Mr. Nzimande, or the EXCO is considering a recommendation from the Ethics Committee written to Mr. Nzimande why his remuneration should not be withheld pending finalization of this matter, and considering that it is no longer in the interest of justice to pay him pending the misconduct finalization. The issue relating to the recusal of magistrates, if we're talking about magistrates, I mean, in both ways, whether it's magistrates or presiding officers in the disciplinary hearings or magistrate in court, but in this case, I presume it is during the disciplinary hearings. Again, it is within the prerogative of that particular presiding officer, given the facts that are presented to him or her, whether they accept or not accept a recusal. And unfortunately, there isn't anything, there's nothing that the commission can actually do to force a presiding officer in a disciplinary hearing or at any time not to recuse themselves. And the quickest possible solution is to replace the presiding officer who's recused themselves. Instead of trying to fight that presiding officer to go back, it might take a little bit longer to do that. And so we do try as soon as, I mean, we've had, the Botlani one was the only one, if my recollection serves me well, except for the many other magistrates in the Nzimande matter that recuse themselves because they're either going on pension and they're not going to be available and so forth. And so we have not been faced with a flooding of recusals of presiding officers in disciplinary hearings, but concern is well noted, and we will open our eyes to it so that we act proactively in the event that it comes to see if there is something that the Commission can do to stop the magistrate from doing that, or the presiding officer rather. Issues relating to reduction of salary, I think it's a good suggestion, although we have started implementing right from the beginning. Now that we have seen the delays that are associated with finalizations of disciplinary hearings, we are now looking at the seriousness of the charges of each and every magistrate that we charge, and we consider in each case, as the Ethics Committee recently, whether a salary should be withheld or not withheld. So yes, at least that suggestion is sitting very, very well with us, and we have started, in fact, implementing it. And then 2 questions related to whether the money is recoverable if the magistrate is found guilty. And that has been an issue which we have been discussing at the Ethics Committee level, whether if a magistrate is found guilty and eventually removed, the salary that the magistrate was paid as at the time that they were charged should not be deducted from their pension fund or recovered in any other way. And that is a discussion we've been having, and we're seriously considering to recommend to the Commission, for the Commission to recommend to the Minister. In fact, in certain instances, and I know I'm speaking out of turn, I'm coming to that issue with resignations. We have somewhat requested the department to advise the regional office not to pay out the pension, to withhold it, and for us to continue with the misconduct. And it had fallen on deaf ears, apparently because there is no legislation regulating it. But I will come to that point as when I deal with that particular point shortly. There was a question also from Honorable Mhlala dealing with a matter that has been reported, and Mr. Finger indicating that the Commission either didn't sit or didn't correct. I am not aware of that matter, but Mr. Finger processes all the matters because they go to the Commission directly. All I can say is we will attend to that particular matter. But this should be taken into account and considered within the perspective of the fact that we receive at least 150 matters per month in any given year. And it's not like one matter coming and having to be processed immediately. It naturally goes on a queue unless it's an extremely urgent matter, which then jumps the queue and comes to the Ethics Committee, either special meeting or monthly meetings to be considered. Sometimes even directly to EXCO, depending on the urgency of the matter. Then I come to that issue of magistrates who have resigned as soon as they either have a wink that they're going to be charged or when they are charged. Again, it is an issue that we have considered as this current Ethics Committee. There are 2 of these kind of issues. One was the request for retirement, when early retirement when the magistrate is charged. And we, as the committee, recommended to the Commission, which in turn recommended to the department not to accept those early retirements. And after obtaining an opinion from the chief law state advisor, the department agreed with us, and it is now policy that if a magistrate is charged, they cannot get early retirement. Then following that, we then saw a pattern of magistrate who resigns once they are being charged, of course, trying to escape the wills of justice. I then, because I'm on the commission on the GCB ticket. I requested the GCB to appoint a senior counsel who's an expert in labor-related issues to provide the commission with an opinion free of charge on pro bono basis whether resignations are justified when magistrates are charged. And that opinion was written and is sitting with the commission. In fact, we've discussed it with Mr. Finger that it had served in the previous meetings, but it was never discussed in details because the commission was sitting for one day and often wouldn't have time to finish its business. And now that the commission is back to sit in 2 days, that's one of the items that is going on the agenda to be discussed so that a recommendation can be made to the departments and eventually to the regional offices not to accept the resignations if a magistrate is charged. But the opinion goes further as to say a magistrate by legislation cannot resign. A magistrate has to be granted permission by the minister to be discharged from office. And therefore that is also on the pipeline. It's something that we have taken note of and we were concerned with and we have acted on. And perhaps after the oncoming meeting in June of the commission, a decision would have been taken as to whether a recommendation should or shouldn't be made to the minister to adopt this legal opinion, in which case then those resignations won't be permitted. And the issue of the public register, again, it's something that we have discussed in this committee. And in fact, we even, I think in the last commission meeting, we informed the DM who was present in the commission's meeting that we intend to start a register that will note every magistrate who either has resigned because they are charged or they have retired or anything after they have had a misconduct hearing so that they don't come back and request for an acting stint from the DM and then they get appointed in a different province. And the commission doesn't even get to know because the minister is the one who's seized with the power to appoint acting magistrate in consultation with the chief magistrate. We also said that register we want to share with the Legal Practice Council so that they have a database of these magistrates who left because of facing misconduct in order for the Legal Practice Council to be able to object in the event that the magistrate wants to go and practice as legal practitioners in any province. So that also is something that we're looking at and we've been discussing for the past few months. The issue of the SOPs, yes, and I did indicate to the select committee that the SOPs was, we drafted SOPs following Parliament advice, and I think it was this portfolio committee, the portfolio committee at some point asking us if we have SOPs, and we did realize that we're operating in the dark, and we complied again. We drafted the SOPs and they went through the processes and they were adopted by the Magistrate Commission. And implementation, we said, will start in April of this year. And unfortunately, why it was not done, it's something that I unfortunately cannot answer. It was not done, and I agree and accept it's basic, but it wasn't, and now we have it, and we intend to utilize it for the operations of the commission. When it comes to backlog audit, that was not because of Parliament. That was our initiative at the Ethics Committee to say there are so many complaints, we're not even sure what we are dealing with. And therefore, the only way that we can be able to know how many matters are in the commission, how many matters are in order, and how many matters are not in order is to ask the department to assist us with the file audit. And I did report in portfolio committee in one of the sittings that is what we intended to do. Indeed, we did ask the department to do the file. The department did assist with the file audit, provided us with the report in November of 2024. In our meeting of April, the cleanup meeting of April 29th, we went through the backlog audit, the file audit report, and we went through each and every matter and realized that, but it's because the Commission's register is not updated. So we, for example, still found Hingas and other Van Schalkwyk and other people that were removed by Parliament still appearing as outstanding matters. So we requested the Secretariat to update their particular register in order to see just how many matters are sitting as old matters. We also tried to action each and every matter. And so now at least we know just what the mammoth of work we still have to deal with, because we've got matters, we've got a file audit, and we've got the report that shows us just what we have in terms of the old matters. In the meeting, we also dealt with new matters that require closure, and I think we closed over 100 matters in that particular week alone in the cleanup meetings. So like I said, we are doing strides. Honorable Mutawung raised issues relating to delays. Like I've explained, there are delays. We are trying to deal with the delays given the resources that we have and given the manner in which the Commission operates. And yes, the pace may still be slow, but it is at least faster than before, I must submit. Regarding the resignations, and we will continue to strive. We'll strive to ensure that at least matters are dealt with, especially those that need closure. They are dealt with within 3 months. People know whether their complaints are being processed or not being processed, and that process has started, and we are positive that we will be able to speak a different language. And I know in the select committee I said by the end of the year, and yes, that's what we're striving to do. All members of the committee are working tirelessly to ensure that the Commission is in a better light than what it was and what it is now. I've dealt with resignations. Mr. Finger will deal with the age of Mr. Nzimande. Honorable Matava again raised the issue of delays and the issue of justification, where there's justification that a salary should be withheld, that I've addressed. I've also addressed the issue dealing with the functioning of the Commission and whether it's functioning optimally or not. It is more about the ethics committee and not the entire Commission, because all complaints are dealt with by the ethics committee. The other committees deal with their responsibilities, either appointments or grievance or salaries or legislative and so forth. So yes, it is functioning optimally currently. We do have challenges. I must admit, time is our enemy like any other person. We've dealt with quite a number of administrative issues that impeded progress in the ethics division. And yeah, now we are on the run, I must submit. I can't say there are no weaknesses in any operation. There should be weaknesses, and I'll be naive if I say we do not have weaknesses or we won't require assistance. And perhaps with the assistance, I mean, financially, we do know that we had a challenge of holding our cleanup meetings previously, but that has since been resolved. And we live, we learn as we go along. Honorable Bredenbach spoke about the report, which is perpetually the same. I agree. And I often ask whether it's necessary to give the history all the time, or we need to give the progress just on the aspect that we didn't report on previously, but we're taking it for granted that some of the members may not have had an opportunity to read it previously, or they were absent, and therefore we give the history over and over again. I've already explained why the matters are moving at a slow pace, that the Commission is doing its utmost best to have these matters finalized. Yes, it is not enough. Yes, any assistance and proposals that will assist us to move forward as speedily as possible, other than what we're doing, is welcomed. I mean, anything that will assist us deal with these matters and finalize them, we will welcome it. Honorable Breitenbach and honorable members, I've dealt with issues of recusal of presiding officers willy-nilly and our powers thereof, or a lack of powers. And it will assist us a great deal, Honorable Breitenbach, if we can get those questions, because it will kind of show us our shortcomings that we might not necessarily see if they come in a form of questions and we are unable to answer. Then we'll be able to know that there is an area which we have not paid attention to that we need to pay attention to, or there is an area that we can improve on that will impact on our deliverance being proper and adequately and optimally than what it is now. I've asked the issue relating to the withholding of remuneration from Honorable Klopper, which was re-emphasis from the other question. The last question he asked is there a way of recovery of the money? And like I said earlier, we really would like to see that happening, because if one has regard to the judgment of Van Rooyen, which says we can withhold salary of a magistrate who is going to be removed should they be found guilty, and that decision is not disproportionate, but that if the magistrate is found not guilty, the commission or the department should pay the magistrate whatever they've lost. Our submission is going to be, and that is what we're going to place, to say, and the opposite should apply, to say, if a magistrate has been paid a total amount of money whilst they were on suspension and they are eventually found guilty and the sanction is removal, they should be able to repay the money. And thank you, Honorable Chair and members.
Thank you, Mr. Finger.
Thank you, Chair. So maybe just 3 issues. In terms of the resignation of members, magistrates that are facing suspension, I think Advocate Managa has indicated that it is something that is subject to a legal opinion, and the Commission will consider that matter in June. But just to indicate that when she mentioned that we've already had an engagement with the DM's office, so we've seen that in the last 3 months before any acting appointment, the DM that the DM processes, they have been coming to us to ask us if there's anything that we would want to comment on that specific person. So at least there's that movement, and at least the members of the public are now guarded against such people. And I think with the LPC as well, there was a letter that was dispatched to them to ask them to say, look, if someone indicates that they were a former magistrate or an active magistrate and they want to apply for admission or to be your member, please request us. And we must say the LPC has been engaging us on that aspect as well. We've been receiving correspondence where they are requesting us to comment on the candidature. In terms of the age of Mr. Nzimande is 65, and like honorable member said, he has given us a notice that he would like to retire at 70. So that is where we are. We still have it still has some few years, but like Advocate Managa indicated, we're undertaking a process to see see that we deal with the issue of the salary whilst he's in suspension. I think the last issue from Honorable Muthala, I think my last correspondence really was with you yesterday. This matter is really receiving attention of the Chief Magistrate, and I think I did undertake that from his side as well, that it's really not a complicated matter. It's a simple matter that requires his attention, and he has undertaken to resolve it this week. I will give you feedback by Friday latest. Thank you, Chair.
Thank you very much, Mr. Finger. Members, I take it that there is no opposition to the fact that Ms. Kekana is on temporal suspension. We're confirming that. Is that in order, members?
It's in order.
Thank you, Mr. Kloba. I take it that we are also endorsing, as the NSOP has done, the removal of Ms. Govender from office. Is that in order,
Yes.
member? Thank you. I think as we are noting the progress that has been tabled by the Commission, of course, it is correct that consistently will always be getting concerns regarding the longevity of these matters. Look, these matters range from 2018, 2016. And quite honestly, some of us are even in a second term now. These matters were already there when we went to Parliament. And it concerns us that time passage on these matters actually hinders progress in terms of either taking them back or appointing new judicial officers. It also, as members have stressed out, it also drains our own fiscal capacity. Look, when Parliament passes the budget, it passes the budget on the Department of Justice and Constitutional Development. It is specifically stressed there that the budget is for the department with a direct transfer for magistrates salaries. So it concerns us that to a certain extent, we think that the budget that which we pass to reimburse magistrates for the work they are doing in disseminating justice to our people is taken for a ride. Because for a number of years, over 5 years now, some 6, some 7, we're paying people who are staying at home. And the reason for that is solely because the Commission is unable to conclude inquiries in time. Now, I think as much as we note and endorse the reports that you give us, I think the only thing that makes us fight every now and then is the issue of the longevity of these matters, which drains our fiscals when we are already in a constrained fiscal environment. I think part of what we ought to do, I'm not sure if the DG is still here, is to request the minister to get close to help the Commission on capacity, particularly the Ethics Committee. Because if you check the report, there are instances where they have to await the NTPP to allocate them a senior advocate, because a term of a previous NTPP would have expired, and then a new NTPP would have been briefed that this is how we're operating, so we must wait and stuff. So I think part of what we must look closer so that we understand if the problem here is not capacity and staff. Because there are instances in the report that says matters had to be postponed on the basis that the person leading evidence would have been indicating that they are retiring and stuff. For numerous occasions, persons leading evidence in the inquiries would have been changed on the basis that this matter is taking much longer than it should be. And I think the commission itself must be able to impose turnaround times on matters on its own. So we'll request the minister to get close to the commission so as to help it to increase a capacity so that these matters are adequately attended to. It shouldn't be yes. Of course, there are issues where we, us ourselves, we concede that this would have been not, this dragged not because of your own incapacity or of your own doing. But some take matters to court and matters end up dragging. But there are things that are within our competence that which we can be able to change to turn around the situation. Because as things stand now, the situation is not looking proper. Your progress report update says a matter of 2016 is still underway in 2025. And that's not how, in our view, we should do this thing. And I think it's important for the commission to enforce discipline to the judicial officers to ensure that we clean out our judicial system. There should never be a doubt on the capacity and impartiality of our judicial officers. Because once they do this thing, they get reported and the matters take longer than anticipated. Those who are reporting to you would actually withdraw their intention or their appetite to report anything to you because you take years to finish the issues. So I think that's the matter that you must focus on. We'll implore the Minister of Justice and Constitutional Development to get closer to you to help you with capacity. I don't know how they are going to be, where they are going to get. We have seen that we have an arrangement with NPA. I think that's part of the way the minister should stand up to ensure that where there is capacity, that is not as more needed than it is needed to the commission. It can be diverted with a proper agreement. So that's the only issue that we wish to raise with you. Members, thank you very much. We have confirmed the temporal suspension of Ms. Kekana. We have confirmed the removal of Ms. Gavender. Thank you very much for the inputs and the direction you have given to this meeting. Thank you very much, Magistrate Commission, Advocate Manaka and Mr. Finger, for the elaborate report. Of course, we're always going to fight. We are going to appear in the next 3 months again. We don't expect to be fighting with this. We want the Magistrate Commission
Chairperson Ngola.
Is someone saying something?
It's me, Honorable Mushlala. I've been trying to unmute. I don't know what's happening. I think they are locking our audio. I've been trying to unmute. I couldn't. I just wanted to ask something before you close.
Okay.
Is it possible, Chairperson, to get the itinerary of the meetings of the Ethics Committee? Because as Mr. Fingers have stated, one of the reasons why they did not even attend to the case I'm referring to, it was due to the fact that the meeting could not correct And then my concern is how many meetings doesn't correlate with this ethics committee. As the presenters also stated, the problem is the ethics committee, is not the magistrate commission. If possible, can we get the itinerary of this ethics committee? I think this is where the matter is lagging behind. We need to attend to ethics committee to operate and take their work seriously, because not so justice delayed is justice denied, Chairperson. Because these people that are raising issues are just poor masses of the people who doesn't have money to follow up with these cases when they delay, and they are chowing from their pairs as well as individuals. So we must never have a situation where a matter of interest or a matter, no matter how small or big it is, it get delayed due to the fact that the meeting of the commission did not correct. More especially after they told us that they use virtuals, they use all kinds of meetings. It cannot be possible that we don't.
And more especially, they said they sit every month.
Follow up on this ethics committee so that it cannot fail the magistrate commission. Thank you.
And more especially on Mhlala, they say they sit every month. I think that's a fair point. So I think let's conclude it on that point. You share with the you share with the committee secretary for your meetings itinerary for the year 2024. Because we've got a research document that there are matters that you did not process, you set once a year. And you are saying, Advocate Managa, there is no such a thing, you see it every month and stuff. So I think the point by Honorable Mhlala is a fair one. Can you please share with the committee secretary your itinerary for meetings that set of the ethics committee, not of the commission, that set last year, the 2024, the year 2024. Mr. Fingers, did you get that point?
We got it, Chair.
Thank you very much, Mr. Fingers. Thank you very much, Advocate Manaka. We are always going to provide support where needed as the committee, as parliament, as legislators. But we must always point out where we think that you are lacking, so that we are actually aware of what then should be the recourse in the weaknesses that we see. So hence we're saying we'll extend a request to the minister to get close to you. So that at least in this regard of the capacity of the ethics committee, they are able to assist. Thank you very much, colleagues.
Can I ask a question, please, on the issue of the schedule? You're saying you want the schedule for the 2024.
Yes.
And 2025, because the schedule that I said we have is 2025. 2024, we did sit, but you will recall I raised the concern that there was an issue relating to the meetings of the ethics committee. We didn't sit once, that's for sure, but there was an issue which related to the venues of the ethics committee meeting, which affected the meetings. So we would not have sat as regularly as we would, but perhaps you can get the schedule from 2023, 2024, 2025 in order to see because then you'll see the problem that we're highlighting about the 2024 issue, and to see that the regular meetings are held. For example, this month we've already met virtually. So yeah, that will be given.
Okay, that's in order. That's on order, Advocate Managa. You can send 2022, 2024, 2025 to the committee secretary. Thank you very much. Members, thank you very much. The meeting is adjourned.
Thank you, Chair and members.
Thank you, Chair.
Recording stopped.